hour of life. Let all the masterminds come together to unwind the path of researchers to fight against this deadly disease. Let the researchers be focused on the vaccines, medicines, etc., to tackle the COVID 19. We should focus on the solution and not merely on the problems. Stay safe and healthy. Thank you. I end my quote. Madam, as usual, those words fire us and inspire us to try to do better. Thank you so much, madam. In fact, our Honorable Vice Chancellor, Sir Professor Dr. Gautam Sengupta, also is not with us today here because, again, he had some very important meetings. So even he has sent a beautiful message to us, and I, Momita Sengupta, again have the privilege to read it out to you. Good evening to all. I am so happy to be able to communicate to the participants of this much needed FDP on intellectual property rights and patent technology. Basically speaking, intellectual property rights are a type of intellectual property protection for those who are the creators. These rights, however, have actually contributed enormously to the world, in particular to economy. Many companies in a variety of industries rely on the enforcement of their patents, trademarks, and copyrights, while consumers can also be assured of quality when they purchase IP-backed products. America's IP is worth approximately 6.6 trillion US dollars, which demonstrates the significance of this subject. The subject is an emerging area of knowledge, much sought after in the present age. I am sure that the participants shall immensely benefit out of this 5 days online FDP. Thanking you all once again for bringing me here to address the participants for this much valuable FDP. And I end the quote here. Thank you so much, Honorable VC Sir, for providing these wonderful words of encouragement. It is now my utmost honor to invite Professor Meghdut Roy Choudhury on stage. Professor Meghdut Roy Choudhury is a serial entrepreneur, community builder, and social change maker. He started his first company at the age of 19, a music recording studio by the name of Blooper House Studios, which has till date produced more than 3,000 albums and hosted artists from across the world. Meghdut Sir has a master's in management with a specialization in international business from HEC Paris, Stanford University, and Tel Aviv University. He is currently the Director Global Operations at Techno India Group, one of the largest education and conglomerates in India, and has been driving a new wave of experiential interdisciplinary learning for adults through the recently established Offbeat CCU, a school of the future. He also runs a co-working space startup incubator called Technopreneur Surrogates Ventures. He has recently been elected as the youngest chairperson of the Entrepreneurs Committee of the Bengal Chamber of Commerce and Industries. Meghdut Sir is effortlessly working to put up best of healthcare and medical infrastructure set up across West Bengal for the COVID patients, and we are so proud of that, sir. Over to you, Meghdut Sir.
Thanks very much, Momita. Just let me know if I'm audible.
Good afternoon, Meghdut. We are there.
Hi, good afternoon. Good afternoon, everyone. Hope I'm audible and visible.
Yeah, you're audible. You're audible. Fine.
Great. Good afternoon, everyone. Happy to be here. It's always nice to see some semblance of reality at a time when everything else seems to be kind of falling apart. I think in the last few weeks, at least, I don't think I've managed to do any real work other than save lives, because I think there's that one constant, thought in the back of the mind that if you're not able to stand beside your fellow citizens at a time of need like this, at a time of crisis like this, what is all the innovation worth? What is all the work that we put in for everything else worth? So with that thought, I'd like to begin. I'd also like to thank my colleagues and the various groups of institutions under the Techno India Group banner for effortlessly, coming up with new solutions towards fighting this COVID crisis, and I'm very grateful for that. Every day, I keep seeing one or the other of the institutions have made some kind of an initiative in fighting the crisis, and it fills my heart up with a lot of joy and pride to see that. So thank you very much for contributing to the fight in your own ways. When it comes to today's topic, which is about intellectual property and patents, I think we stand at the juncture of maybe one of the most interesting debates and life-settling debates on this particular field, when global organizations and influencers and massive conglomerates, including say somebody like Bill Gates, who has access to so many patents for the COVID vaccine, have outright denied to provide that to so many countries. And it all comes down to that same point, right? That is it for the benefit of science, or is it for the benefit of humanity? And we stand at this juncture where we don't really know the answers exactly, because how we go ahead in these next few weeks or months during the COVID crisis is going to determine what happens with the world, and who are the people who are left in a way. And however dark it may sound, that is the way that it is right now. So really bizarre time, but I'm glad that such events on innovation and on the need of intellectual property and patents are being discussed, even at the university level. Even though we have not been able to come up with, say, things like our own vaccine, for example. It would be very interesting to see Techno India coming forward and creating its own vaccine, but it's not that simple. There are certain organizations which have in fact approached us to get us access to licensing for vaccines in the future. But it's a very uncertain uncertain future, we must understand. And so sometimes, even though it does get me very excited and riled up to feel that maybe Techno India tomorrow can come up with its own patents, or stand with the medical fraternity to provide vaccines for its people, creating them from scratch seems a bit too futuristic right now, considering so many people are dying right now. So at least on behalf of Techno India, what I can say is we are trying our best to provide mass vaccination camps for people, and using other people's IP, other people's patents, be it that of Serum Institute or Bharat Biotech, or Dr. Reddy, who's taken up Dr. Reddy's labs, who's taken up the Sputnik 5 vaccines, trying and seeing that they are able to reach the people. So that end mile delivery is also important. It's not just about having the access to the patents. And one more point I'd like to add here, I think this is something that's been bothering me quite a bit, like from the ground, from the COVID relief fight that we're all fighting collectively as a nation right now, because God forbid, I really hope we never have to see another one of these again. I can understand how much collective pain and pressure we're all going through. But one thing that's been really bothering me, for example, is the fact that Serum Institute, let's take the example of Serum Institute, for example, inspired being one of the forerunners in the fight against COVID, and in terms of creating the vaccine and having a patented vaccine which had all the necessary trials, the clinical trials, and all the clearances. They were not able to, in fact, provide enough vaccines to fight with this virus in a better way. I mean, they had a huge, time that they had even before the second wave hit. In that time, a lot more work could have been done. I'm not pointing fingers here. I'm not saying that they are the only ones who are responsible. I'm guessing it's a huge machinery and it requires lots of clearances, etc. But when there's an incredible emergency like this, like the one that we're seeing right now, every effort to go above and beyond our capabilities is what sets us aside as innovators, or as people who are looking forward into the future, as opposed to people who don't have that kind of resources or who don't have that kind of soft power. So what I believe is if I think there could have been a better deployment plan that could have been done. Just having access to vaccines and patents, patents on vaccines and intellectual property on vaccines is not enough. It's also about figuring out a way of deploying them. The logic is very similar to when we do PhDs, right? In 99% of the cases, somebody does a PhD, writes a huge thesis, and they're the only ones ever to read those PhD theses because they never get referenced, they don't get used by other people, they don't get quoted, and hence it lies in a bookshelf somewhere collecting dust. So I believe we at a time when universities more and more are accommodating entrepreneurship cells, they're accommodating institutions, innovation councils, they're accommodating innovative camps and faculty development programs such as this. Academia also needs to come forward and work on plans of deployment, create entrepreneurs from within who can take these patents and intellectual property and trademarks to a stage where they're actually utilizable for the end audience, for the consumers, for the citizens. So with that, I will stop here today. Unfortunately, I have another meeting that I need to go, and this also is something else for COVID relief, and it's been a time of flurry in general. But I'm glad I could make it for a little while and address all of you. Hope all of you are keeping well. It's obviously a very, very difficult time, and I hope your families are keeping well, and our support from Techno India is there with you always. And we'll try to, as soon as we get the next access to vaccines, which we're hoping should be in the next couple of weeks, we will let you all know so that we can come forward and organize mass vaccination drives for the stakeholders, both internal and external, who are associated with Techno India Group. With that, I am going to take your leave. Thank you very much for joining in today, and have a wonderful faculty development program. Thank you.
Thank you so much, sir. That is really, really a welcome hope that we are all being provided. So thank you very much, sir, for that ray of hope that we have. And we will win. With the help of Techno India, we will definitely win. I would now invite Professor Dr. Sujoy Vishash, the Director and CEO of Techno India University and Techno India Group. And though Dr. Vishash really needs no introduction for any of us, but I would like to introduce Dr. Vishash today at this forum. So, sir, a brief introduction of yours, I will read out. After completing his schooling from South Point, Dr. Vishash completed his BTech in Civil Engineering from Jadavpur, MTech from Acharya Nagarjuna University, and PhD from Sri Satya Sai University. He also secured first position in MBA from IISWBM under Calcutta University. He's serving Techno India Group for last 12 years. In addition to his administrative responsibility, Dr. Vishash is also the mentor for civil engineering, architecture, and management department of all the institutions of the group. He is also an active member of the doctoral research committee and the guide and co-guide of several PhD scholars. He is a leading chartered engineer and real estate valuer empaneled with major nationalized and private banks of the country. He started his illustrious career with the largest steel plant consultancy in the world, M.N. Dastur Company, and served the organization for 12 years. He served one of the topmost software companies, DSQ, for a couple of years. He also headed West Bengal Police computerization for the next 7 years, where Webel did the front ending. Professor Vishash is a member of several chambers of commerce, which includes ASSOCHAM, BNCCI, ICCC, IACC, and Indo-American Chamber of Commerce. Dr. Vishash is much sought after, an outstanding motivational speaker, an anchor and director of one of the most popular and unique celebrity shows, Joy Pothe Shonge Sujoy, currently 254th week. Coronar Kahini Shonge Sujoy is another very popular program. He owns a musical band and is the lead singer of Throi. He's an avid social worker and the patron of the NGO Srijan Shobha, which supports children with autism and similar physical and mental challenges. Dr. Vishash, over to you. Sir, you are muted.
Thank you, Momita, for the lovely introduction. And actually, these are very hard days. These are very challenging days. None of us are really happy in the sense that we do not know where we are heading to. But as you said, Amra Korbo Joy Nishchoy, we are definitely going to win over this pandemic. But what is important is, and what is very true is that life is going to go on. Trust me, life is going. No pandemic has been ever been able to end the civilization. So it will go on. So we need to keep on working. You know, every morning I tell a prayer to myself. It's called the prayer of serenity, where it says that God grant me the serenity to accept things that I cannot change, courage to change the things that I can, and wisdom to know the difference between what I can and what I cannot. And that's what I practice every day. And what we can is, that's the reason I'm trying what I'm trying through my television programs, through my YouTube handles, from my social handles, to inspire the young people, to inspire people who are getting demotivated, who are getting de-inspired, who are feeling that where are we every day, some or the other near and dear persons, maybe relatives, maybe colleagues and other people. I'm very upset with the demise of our Gaudiya principal, Sujata Ghatak, such a lovely person, such a vibrant person with all love, with all the smiles in her. I remember her every time. In fact, she was in our video when we did it last time as Corona started, and she's there no more. So it's as blunt as that. But at the same time, life should go on. So intellectual property rights and patent technology and research and innovation, this online faculty development program for the 5 days is going to remember us that at the end of the day, we need to have certain knowledges which will help us when the days turn around, which they will surely do. And this is one of the areas that I work upon functionally. You mentioned in my profile that I'm a valuer for the banks. You know, I'm a valuer for most of the banks, and I work on intellectual properties. Intellectual property has the value of their own. The patents and the IPRs have the value. So just a little bit of statement on the IPR and the patent technology before I conclude with some shari or motivational word. I quote as I say, innovation is crucial. Innovation is crucial to the development and deployment of technologies. A widely deployed model to understand technology builds on the concept of technology life cycle. The life cycle of technologies can be divided into stages from one invention, invention, then through research development, dissemination, R&D, and that is research development and dissemination, and then market development to commercialize diffusion. Different processes occur at each stage of the life cycle, providing various opportunities to employ instruments that promote innovation. Innovation is very important. Innovation is the one which can make the difference in anyone's life, any society's life, any country's life. One group of such instrument relates to IPR. This is one group. IPR and patent technology are two different stuff. So one group of such instruments relates to IPR. IPR refers broadly to the ownership of intellectual findings in the industrial, scientific, literary, and artistic fields. I repeat, IPR refers to broadly to the ownership of intellectual findings in the industrial, scientific, literary, and artistic fields. IPR grants inventors certain exclusive rights over their creation. It aims to be creative. It aims for creative activity for the benefit of the society by affording investors an opportunity to derive their fair returns from investment. Because you do certain things and then you do not get the return, then you won't get the kick to do the further one. Traditionally, IPR is divided into two forms: industrial property rights and copyright. In general, copyright is legal term describing rights given to creators over literary and artistic sphere. This is very right. You know, copyright is for creators over literary and artistic creations broadly, while the term industrial property rights refers to certain exclusive rights regarding innovation ideas or distinguishing signs in the industrial or commercial field. Industrial property takes a range of forms and includes patents to protect inventions, trademarks, industrial designs, and commercial names. Patents can play a prominent role in the entire technology life cycle, from initial R&D and dissemination to market introduction, demonstration to diffusion, and allow competitive technologies to be protected and licensed to third parties to expand financial opportunities. Global patenting opportunity, as the Vice Chancellor maintained, the global patenting activity is on the rise. World intellectual property indicators show the total number of patent filings, trust me, total number of patent filings worldwide has increased over 10% on a year-to-year basis. So people are innovative, people are getting patents, and that is rising to a 10% basis. A patent is the right granted to the patent holder by a state or by regional office acting for several states, which allows the patent holder to exclude others from commercially exploiting their invention for a limited period without authorization. That is very important. I innovate something, I patent, I do not patent, and you use it. Means that is something in Bengali amra boli nepoi mare doi. So that cannot be done, you know. So by granting such right, patents provide incentives for innovators, offering them recognition for their creativity and enabling them to appropriate the returns on the investment. So they get an ROI because during the times they're innovating, they have to invest on that. So if they do not get ROI, it's not going to happen. A patent may be a powerful business tool allowing innovators to gain exclusively over a new product or process, develop a strong market position, and earn additional revenue through licensing. I come to the concluding part where I said that patent protection is usually sought at the research and development stage of the technology life cycle. Various departments in companies, including research units and specialized lawyers, play a key role in the development of inventions as well as in the process of preparing and filing patent applications and obtaining, maintaining, and exploiting patents. In return for the exclusive rights, the inventor must disclose, এটা কিন্তু একটা very important, this is one very important point. In return for the exclusive rights, the inventor must disclose sufficient information regarding the patent invention. Why? Because that will enable the public to allow others to access and further develop the technology. He cannot make it totally closed. First, it should be known how it, and that is happened for this coronavirus vaccines also. That whatever they have done, they have, and the Lancet has published. The disclosure of the invention is an essential consideration in any patent granting application. In this way, the patent system is designed to balance the interests of investors and the public. So these are the technical things that I wanted to mention. Trust me, I would not have enjoyed uh, working out on patent and IPR because people are so sad, so upset that you cannot think of anything beyond life. But first we should exist, and then there is patenting, then there is IPR, everything. We need to be very careful. We need to be very careful. What we need to do, we need to put our mask on. Trust me, I'm in the office. There is no other person in the office, so the mask is there. You need to use the sanitizer. You need to use the sanitizer. You should have this kind of disinfect spray where you sit and so that it enables you if you are going out. Even it says that even if you are vaccinated and you are in your residence, try to maintain a social distance. If you are not, if you are vaccinated and the other person is not. So these are the stuff that I needed to try. I'm working with the Meghdut for his initiatives. He's doing a priceless activity for saving lives of the people, ramping up the beds in the Technodama hospital, trying to, I'm also working with him for getting the vaccines from Serum Institute specifically. I have not acted for Bharat Biotech, but for Serum Institute, I had been in touch with all the levels and supporting him to get that. We are also trying to get a corporate tie-up. So we are trying to, under the leadership of Meghdut, we are trying to make a difference to our life. That is, in fact, human life is priceless. If the human life is saved, then the whole, the society, the whole generation, the whole gamut of our activities is going to save. So while we talk of intellectual property, patent, as we hear from today, Dr. Indranil Shah, tomorrow from Parvez Kudroli and Mr. Shomik Banerjee, day after tomorrow, Mr. Shailendra Bhandare and Mr. Dr. Dhananjay Shah, then Mr. Saurabh Trivedi and Dr. Shambhu Prasad Chakraborty, and lastly, on the closing day, Dr. Shreya Matilal. So we will listen to them. We will have, because knowledge is cumulative. Knowledge should be intrinsic. Knowledge should be, it should be internalized. I mean, Bangla bole attostho kora. So knowledge should be there so that after this is over, so we are going to use this knowledge for the glory of mankind, for taking the name of Techno India to levels beyond our imagination, to every part. In fact, Techno Indians that are there in different parts of the world. And I will end by quoting the formula of success, and we are trying to do that. It says, and I quote, "Success is failure turned inside out, the silver tint of clouds of doubt, and you never know how close you are. You may be near, but it seems so far. So stick to the fight when you're hardest hit. Stick to the fight when you're hardest hit. It's when things seem worse that you must not quit. It's when things seem worse that you must not quit. Please do not quit. Trust me, this is going to be over maybe by the end of June or the middle of July. There may be a third wave in October, November, but by this year we are going to have the vaccines are being produced. They are coming. We are trying to vaccinate, mass vaccination. We're trying to do mass vaccination, and we'll be over by the year or early next year, and we'll have the same life. So we'll go on. And as I end, I would say that कोशिश करने वालों की कभी हार नहीं होता. So Techno India is going to make the difference in people's lives, not only with patent and intellectual properties, but giving price or support for saving lives which are priceless. And we are, you know, totally committed towards our goal and motivation. Thank you. Thank you, Momita.
Thank you, sir. Again, you provide us with immense hope and immense encouragement,
Thank you.
not to be negative and not to just get bogged down by grief, but feel blessed and go on that we can make this effort. Thank you very much, sir. Thank you.
Thank you. Thank you.
Thank you. I now invite Mr. Ravi Ranjan, the Chief of Entrepreneurship and Innovation Strategy and Head of New Age Programs and President of the institution's Innovation Council, Techno India University. Ravi, are you there?
Thank you so much, Professor Sen Gupta. I would like to first of all congratulate the entire team of Techno India IC IPR segment led by Ms. Rupal Betai and supported by Professor Paul and Professor Amrita. Thank you so much for your leadership. With your leadership, we have been able to make this very, very powerful, impactful, and very important faculty development program. I'll talk more about that, but to start with, congratulations. We move on, and before I move on, I would like to take a moment to quickly check if all of us are doing well. I understand it has been a very difficult scenario. Meghdut spoke about the challenges, but more importantly, he spoke about the solutions. I'm sure all of us in our personal capacity, we are trying to help each other. Even if we cannot, just by maintaining social distancing, whenever we venture out, we take all precautions. Trust me, you would be contributing to the overall ecosystem, and we are trying to reduce the virus impact. So let's be very careful, very, very sincere about our approach whenever we step out in the open about so that we can curb the virus. That's one. Number two, unfortunately, a lot of lives have been lost. So I just want to take this opportunity to share my sincere thoughts in regards to all the people, all the loved ones we lost, or who are going through a difficult time. Let's try and be empathetic towards all the people. With that, I would like to move on to the agenda of the day. As we all understand, Techno India Group has always taken pride in talking about innovative approach. We always talk about how we can be the first mover in any of the segment. Last couple of years has been very active at Techno India, where we have tried to put a lot of emphasis on entrepreneurship, strategy, innovation, and open innovation. Some of the examples are Future Proof Hackathon, which we organized last year at the beginning of the pandemic. We also did a very powerful toy hackathon. In fact, now AICT is working closely with Techno India in organizing the next set of toy hackathon. We realized that apart from all these activities which are happening in the field of entrepreneurship and innovation, one of the most important element is IPR, patents, trademark, copyright. What is it? Why we need to focus around IPR, and why is it important for an academia like Techno India Group to focus onto this? Let me share some very quick stories, and then I'll talk about a brief outline for the next 5 days. It was the summer of 1963, where a young person was, chilling outside in a park with his family, and he was enjoying a cold beer. Unfortunately, he was not able to open that can because there was no opener available. This was 1963. The place was Dayton, Ohio, in the US. He figured out that a lot of people across the world would be facing the same problem, because at that point of time, the cans were made of aluminum, and you need to have a special can opener which you put on top of the can and then you open it. It's a very difficult process. People used to hurt themselves as well because it was sharp object which was involved. This gentleman, he went on and he realized that I need to solve this problem. His name, was Ermal Cleon Fraise. What he built is today one of the most powerful but the most simple innovation which you all must have seen is the pull tab on the can. I'm sure you have purchased a soft drink or a juice and you have seen that small tab on the aluminum can. You pull that and you have this very simple to use can. Today that innovation is used by almost all the beverages company in the world, and every single time someone opens a can anywhere in the world, the inventor and the organization associated with the invention receives a royalty. Imagine the amount of money which this invention has fetched so far. Just a quick story about how small innovations can impact our life in a really big way. Some of the other innovation today, while we are going through a very difficult pandemic situation, you will see that today we are talking about making patents affordable and open to everyone. Today, all the top organizations and the countries in the world are talking about making innovations primarily around the COVID vaccine affordable, because I'm sure you are aware that today more than 100 countries across the world have not received even a single dose of vaccine. India is fortunate that we have access to vaccine right from the month of January. But today, a lot of poor countries across the world do not have access to vaccine because large pharmaceutical companies who invent these vaccines, they have a IPR, which means that only they can use the formula to make that particular vaccine. Today, there are discussions on how to make these patents public. You can understand how powerful having a patent is. There are a lot of universities across the world, primarily in the US and Europe, where faculties work every single day to bring more and more innovation in the field where they are working, which is mechanical, computer science, healthcare. We are also very sure that Techno India Group has a lot of innovators. Some of our faculty members are already, they have applied for patent, they have received patents, and I'm sure after the 5-day FDP which we have organized, we'll see more and more examples of faculties coming in and filing for these patents. So I just wanted to share these very quick thoughts, and I would let the speakers talk more about it. To summarize, this is what we have planned for the next 5 days. We start with the opening ceremony today, and then we move on to the technical session where we talk about various components of IPR, which includes patent, how to draft a patent. We speak about how to apply for trademark, copyright. What we have done with the help of all the team members who have worked for past many days. We have tried to bring some of the best speakers from the industry, which have, these speakers have practical experience of working on the ground with entrepreneurs, business owners for past many years. Together, combined, all these speakers bring over 100 years of IPR expertise. Let me share some very quick insight. For example, Mr. Shamik Banerjee, he is one of our speakers on 18th of May. He has worked with the World Intellectual Property Organizations in Geneva. He has worked with WIPO. He has worked with United Nations on various IPR related issues. We have Mr. Parvez Kudroli with us, who is a principal associate with Khurana and Khurana. Khurana and Khurana is a legal firm based out of New Delhi. They have been working very closely with Government of India in the field of IPR. We have Dr. Indranil Saha. Dr. Saha has spent a lot of time. He's from IIT Kharagpur. He has worked with UNESCO. He has worked with IISc. He has a PhD from IISc Bangalore, and he brings immense expertise in the field of IPR. Similarly, our speakers such as Dr. Shreya Matilal, Dr. Shambhu Prasad Chaudhary, Mr. Saurav Trivedi, Dr. Dhananjay Saha, Mr. Shalandra Bhandare from Khaitan and Partners. These are some of the names. When you do a Google search about IPR experts, these are the top names which comes. We at Techno India University have worked really hard to make sure that we have brought the best names in the field of intellectual property rights, patents, copyright, trademark, to ensure that over the next 5 days, we go through a gradual upgrade. We start with the basics of IPR and then we eventually go and cover the more complicated and more important aspect. We have also invited some of the experts from within the Techno India group who will come and share their expertise of how they have worked in the field of IPR. With this, I would like to once again congratulate the team of IIC Techno India University IPR led by Rupal and team to make this event very, very successful. I would also like to take this opportunity to thank Dr. Reena Paladhi ma'am for your continuous guidance, Professor Dr. Sujoy Biswas for your continuous guidance, Meghdut, who has been a great mentor, friend, and help to all who always encourage us to do these kind of events. Many thanks to co-chairman ma'am, who shared her thoughts with all of us for the event, and everybody else who has been involved in making this event successful. I'll share more about all the people, and we'll also try and meet once again towards the end of the session. But for now, we have 5 amazing, exciting days where we'll have some of the best speakers, as I mentioned, from India and hopefully globally, who will be able to help you go through this entire journey. Thank you so much. Over to you, Professor Sen Gupta.
Thank you very much, Ravi. So before I move on to the speaker of the day, I would like to say a few things regarding the settings today. Of course, this was an inaugural session, but otherwise, when we are going through the FGP, then you can raise hand or you can send over queries in the chat box or in the Q&A boxes. So that is something that you can do. Maybe the mute button will be on at that point of time, so that when the speaker is speaking, then there is less of an interference. So that is something that I needed to tell you, and also a few instructions which the organizers have asked me to pass on. That is something that you will actually have a feedback form right on the 21st, when we are ending the program. So feedback form, which you will fill up and submit by the next day. The link will be open for 24 hours. So whenever it is being given, so within 24 hours, you have to give the feedback form. And there will be a small assessment, MCQ assessment test, sometime next week, most probably, Tuesday. Maybe, you will be given the link, and you will be given some particular time in which you will have to do it. But well, don't worry. I've been specifically asked to assure you that this is not some kind of a school exam or anything. So don't get all hyper about it. And even if somebody is unable to provide this assessment, doesn't mean that you're not getting your certificates. Your certificates will be mailed to you within, I think, 2 weeks. At the most, they can take 3 weeks, but you will definitely get your certificates. This assessment is just, for your takeaways. I mean, what are your thoughts? What could you discern after going through this very wonderful process of knowledge creation and knowledge development? This is all I had to say, as I have been told to give these few factors. And with this, I now have the honor to introduce the speaker for today, Dr. Indranil Saha. Dr. Indranil Saha is the founder of Heinz Legal. He is an MSc from Presidency College and a PhD from IISc Bangalore. He has a doctorate from UNESCO, Italy, LLB with an honors in IPR from IIT Kharagpur. So indeed, somebody who is multi-talented. Dr. Indranil Saha is the founder of a full-service law firm called Heinz Legal, and has a combined experience of more than 15 years in the field of science, technology, and law. After MSc in physics with the first class from Presidency, he completed his PhD from Department of Physics at IISc Bangalore. Thereafter, Dr. Shah completed his postdoctoral studies from UNESCO at Italy. Following this, Dr. Shah ranked All India 5th in the IIT Kharagpur All India Law Entrance Examination and completed his LLB from Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur. Dr. Saha has also been appointed by IBBI, Insolvency and Bankruptcy Board of India, Ministry of Corporate Affairs, Government of India, as an expert for providing legal opinion and working on academic matters in relation to IBBI, and also been invited as a speaker at several key summits. Dr. Saha, a very warm welcome to you, and we give over the mic to you.
Thank you, ma'am. Am I audible?
Yes, sir. Yes, sir. You're
Yeah. Thank you, Professor Sengupta, for the kind introduction. And first,
Dr. Saha, sorry for the interruption. If I may request you, it looks like there is some dirt on your camera pinhole. You might want to just clean that up so that we can see you clearly.
Okay.
Otherwise, everything is perfect. Thank you so much.
Yeah. Is that okay now? Can you just...
Much better, much better. Please go ahead.
Or can I do something? Actually, can I log in from the phone, and when I share the slides, that I can do through the laptop? Would that be okay?
Absolutely up to you, Dr.
Yeah, let's try that. Just
thanks a lot. While Dr. Saha joins again, just wanted to share very quickly with all the participants. Today we are using the Zoom webinar mode, which is a little different from the Zoom meeting, which means that during this mode you would not be able to broadcast your audio or video. This has been done just for the efficiency in the program, because sometimes what happens is that there's some background noise and it becomes distracting. It is in no way designed to discourage you from asking questions. We actually encourage you to ask any questions which you want. Feel free to put down your questions on the Q&A option on your Zoom dashboard, or use the chat option. Also, if you want to ask any question, please click on the option called raise hand, and the host will be able to pass on the mic access to you when you open the Q&A session at every day towards the end. So these are the three things: Q&A, chat, and the raise hand option you can use to ask the questions. Also, if you have any problem at any point of time, do not hesitate and do let the host know, and we'll try and solve that. Thank you so much. Dr. Saha, please go ahead. I think this is absolutely perfect now.
okay. Thank you so much. Am I audible clearly?
Yes, you are.
Yeah, thank you. So thank you, first of all, the organizers, Techno India Group and Techno India University, for this great opportunity that has been bestowed upon me, and with a high responsibility, with along the other speakers in this 5-day long faculty development program on IPR and patent technology in research and innovation. And it's a very important and interesting topic that the organizers have chosen, because especially with the lockdown in force and with a lot of innovations, as the other inaugural speakers have just mentioned before, regarding various kinds of groups trying to make vaccines and other stuff, which is really helpful for fighting of corona. IPR has taken a lead position among all the other kinds of property rights, especially patents is of great importance nowadays. And patent technology, I should say patent is basically a right that protects technology, is very, very essential for any group which is either in the industry directly, like a pharma company or like a manufacturing unit, or even IITs, other educational institutes, because these are hubs where actually academic research is carried out, and academic research is very, very important and is the base route for any industrial research. Okay, please do not be under this idea that only high-level research occurs in industry. The root and the base starts from academics, because the students with those brilliant young minds, they are all into the academic region, and only after that they enter into the industry. So unless we train our young people at the grassroots level with knowledge, especially in IPR region, we cannot expect that we would be a heavily industrially flourished country. So there IPR takes a very important role. And I would definitely like to thank, among the organizers, Professor Dr. Vishash, who is the director of the Techno India Group as Techno India University, and who gave very insightful talk regarding the importance of IPR, the various kinds of IPR, and why we need To follow this, Mr. Meghud Roy Chaudhary, who is the Director of Global Operations of Techno India Group. Thank you, sir, for your nice talk. Mrs. Manushi Roy Chaudhary, who is the co-chairperson of the Techno India Group. Professor Gautam Gupta, the Vice Chancellor of the Techno India University. Mr. Ravi Ranjan, thank you, sir, for your kind introduction. And definitely Ms. Rupal Betai and her team, including Ms. Prama Bakchi, who have been in contact with me and have been tirelessly working to get this whole 5-day online IPR innovation and patent technology based platform and get it going actually. So with that note of thanks, basically, which I would like to present in the beginning, because at the end I may not have time. So I will get on to the first topic of today, which I'm going to give. I'm going to give 2 talks today actually. Both are related to patents. In this first talk, I will be talking about patents, innovations, and startups, and how patent technology is important, what is innovation, how startups and small and medium scale industries are important in the proliferation and growth of the company, and why at all should a person think of opening a startup and not a very big company, or why are youngsters nowadays going into this era of, okay, I want to open up a company, which is a really fantastic thing. We did not have all the scopes during the time we studied some 15-20 years back. So this is a very important era that we are going through, which is changing India in multifarious forms. And specifically IPR helps in proliferation of these ideas and establishing young entrepreneurs in the country who can take the country forward. So we will go to the first topic, and I would like to share slides actually. Can you just tell me, can anyone in the panel tell me how am I supposed to share my screen here? Because I am not seeing any control given to me to share screen.
So you should have a share screen button.
Yeah, okay, I got it down. Let me try. Is this screen visible to everybody? Can you just say something?
Yeah, it's completely fine.
Yes, sir, it is visible.
Okay. Thank you. So that's the first talk for today, which is patents, innovations, and startups.
I think he has accidentally muted himself.
Hello, am I audible now?
Yeah, yes, sir, you are audible.
Yeah, I also got disconnected, ma'am, actually, suddenly from both my phone as well as from the laptop.
Okay. So sorry, sir. I hope you can continue.
Yes, thank you.
Yeah.
So is the next slide visible to everybody, where I have shown the electric bulb?
Its share is not.
Wait. Okay, let me. Now?
Yes, sir. Now it is visible.
Okay,
yes.
Okay, thank you, ma'am. So in this next slide, I have shown a very simple example of what is known as an invention. I have just shown an incandescent bulb or an electric bulb that has a filament that is covered by a glass, which has got very high melting point because it gets heated up to very high temperature. It has inert gas. It has more or less very high vacuum inside, because you cannot put a gas inside a bulb. It's going to explode. And then the bulb is connected to the socket through an aluminum connection, and it has electrical connections together in it. Okay. Now the question is, what is an invention and what is an innovation? This is first what I think we need to understand. Most people nowadays use the term interchangeably. which is not the correct thing to do. There is a lot of difference between what is difference scientifically as well as legally as to what is an invention, what is an innovation. Now, invention is something which is defined by the law. By the law, meaning the patent law of the country. In India, it is defined by the Indian Patents Act 1970. If you go to China, it will be defined by their patent act. If you go to USA, it will be defined by their patent act as to what each country says what an invention is. So quite contrary to the common belief where a scientist working in the laboratory of a university or a company, whatever he thinks he has invented his invention, it is not so. Invention has to meet certain criteria legally, or I should say techno-legally, because it's scientific stuff, and only then it can qualify as an invention. However, innovation is the dots that connects various inventions together to make make a product or a process commercially viable into the market which people can use. Now, why did I place this electric bulb? If you look at this electric bulb, you see this glass which is covering that bulb. Okay, now that glass is not the normal glass that we have, which we are using for in the cups and plates. It's a different kind of a glass, so definitely it may be a patented kind of an invention. The tungsten filament that has been used, okay, there is a way in which it has been coiled, and it is not the raw tungsten that one can get in the laboratory. There is a method in which it is produced, so that is an invention by itself. The holder which is down, which connects the bulb filament with the electrical supply outside to the socket, the way it has been manufactured, that itself is an invention. And look at what the innovation is. This company which is making this electric bulb, it has connected the dots between that filament, that glass envelope, that socket, and various other things which are individual inventions to make a product which can be used by the people in the market, and called it the electric bulb. Okay, so invention is what the law is defining under the Patents Act, whereas innovation is basically, is the job of an entrepreneur, primarily. Also, people in the industry, scientists also, who connect the dots between various inventions and try and make a product or a process commercially available in the market. Okay, so this is the basic difference. Now, the next slide. So, what is a patent basically? Now, patent is basically, it's a property right. This is the first thing that one needs to understand. The patent is just a property right. Specifically, it's an intellectual property right, because it is something which is a creation out of the intellect of an individual human being. Okay, so there are various other kinds of rights also, which the other speakers will speak in these 5 days. Just to give a very preliminary idea. If it is a property right associated with inventions, scientific inventions, we talk about patents. If it is a property right associated with creativity relating to literary, artistic, musical work, sound recording, etc., etc., then it will come under copyright. If it has something to do with the protection of trade name, it will be trademark. If it has something to do with the protection of the geographical indication, then it will be GI, so on and so forth. Okay, so these are the various kinds of classes of intellectual property that we have. I'll be talking specifically on patents, and we'll be dealing with the Indian Patents Act here, not the American or the Chinese or any other patent act. So patent is basically a property right, and also an ownership right. And who gives this right? It is granted by the government. To whom? To the applicant, for the protection of his or her invention. Now, what is the tenure of this protection that is given? It is 20 years from the date of the application. And one more important thing one has to remember, that patent is a territorial right. Territorial means it's a geographical territorial right. So if one has a patent under the Indian Patents Act, then one can enforce the rights of that patent only in India, and you cannot extend that right to America, China, Japan, or whatsoever. If you want your patent rights in those countries, you have to apply separately to those countries or through certain international rules, which I will talk in very brief during my talk. And so please remember that whenever you have a patent, patent is specific to a country, because it is given by the government of that country. So it is territorial in nature. So if someone gets a patent under the Indian Patents Act, that patent right or that patentee can enforce his or her rights throughout the territory of India, but not elsewhere. So now, what is an invention? Because I was saying we must first have an invention to have an innovation, right? So what is an invention? And I also said that whatever the scientist is making in the laboratory, be it a product or a process, is always not an invention. So the law in this respect is very, very clear, crystal clear. The Indian Patent Act, Section 2J defines what is an invention. Okay, so it says invention means a new product or a process. So in India, if you are claiming an invention, firstly it has to be a product or a process, or it could be a product by process, but nothing else. Okay, and such product or a process should involve an inventive step. Now, what is an inventive step? We'll see. It is defined in the Act, and it should also be capable of industrial application. So, if a scientist makes something in the laboratory, be it a new product or a process, then that such product or a process must have an inventive step and also should also be capable of industrial application. Only then the law will recognize that scientific discovery to be an invention legally, and you can sort out for a patent right, which can be used in multifarious ways for proliferation of the research as well as earning profits out of it, but not otherwise. So it's very important to understand legally what is an invention. So this is what we understood, and here there are two new words: inventive step and capable of industrial application. Let's see what they are. Now, inventive step. Law also defines what is an inventive step in section 2JA. So it is very, very clear. It says inventive step means a feature of an invention. Okay, so what of an invention? Feature or characteristics of an invention, which should involve technical advancement as compared to the existing knowledge, or having economic significance or both, and which does not make the person obvious to the person skilled in the art. Now, here there are two terms here. Okay, does not make the invention obvious to a person skilled in the art. Now, what is the meaning of does not make it obvious? How are we going to test what is obvious, what is not obvious? There are legal tests to do this, and I will just brief you as to what test is employed by the patent office for determining the criteria of whether there is an inventive step in your patent application or not. So very simply, if I'm claiming that I have made an invention, then that should have an inventive step. And for an invention to have an inventive step, I should be able to prove that my invention has higher technical advance or involves technical advance as compared to what is already existing in knowledge in the world. Now, existing knowledge may be academic, may be non-academic, it may be industrial, may be non-industrial, it may be published anywhere, it may be even published in the pamphlet of a magazine. It does not matter. It does not always have to be a scientific journal. My invention should have a technical advancement as compared to the existing knowledge of what is available on the face of the earth, basically, on or before the date of filing of my application for patent. Okay, so before or on the date of filing of my application, it should have technical advancement, and it should not make my invention obvious to a person skilled in the art. Now, who is a person skilled in the art? So in India, we have this criteria called skilled in the art. Skilled in the art, for example, say let me take chemical invention. Okay, so any person who chemical invention involving synthetic organic chemistry. So any organic chemist who is working in the field of either industry or academics is a person skilled in the art. You will take an electrical engineering invention. So any electrical engineer who is working in that domain is a person skilled in the art in that domain. Okay, so on and so on. So we have understood now inventive step, which is must for my invention. Then we saw capable of industrial application. So capable of industrial application in relation to an invention means, what does it mean? These are legal meanings. Okay, it means that the invention is capable of being made or used in an industry. And why capable of industrial application clause has been kept in law for a discovery to be an invention? This is because, as you know, Professor Dr. Dr Vishash said that if somebody has a patent right given by the government to that patentee, and that person does not utilize that patent for the benefit of the mankind and keeps everything to himself or herself, then there is no utility for giving that patent right to that person. So you have to bring your patent out in the market, try to make it industrially applicable so that, you know, people get benefit out of your invention. And this is the reason you are being given a patent right for 20 years. If you are not doing this, then you cannot get a patent. So this is the reason as to why the capable of industrial application clause has been kept in the Indian Patents Act. Okay, now I said that in India, if you want to have a patent, it has to either be a product or a process, okay, or could be a product by process. But all these product or process that we're talking about have to be new product or a new process. Okay, now, so it has to be a new invention basically. So now what is new invention? The Indian Patents Act also helps us to understand what is a new invention. So section 2L clearly states what is a new invention. So it says new invention means any invention or technology which has not been anticipated by publication. Okay, so now not been anticipated, this is again a legal term, just like we saw. It is not obvious to a person skilled in the art. Obviousness is a legal term, anticipation is a legal term, which I will explain how the patent office checks whether it is a new invention, how the patent office checks whether it is a invention having invented step or not. And so this should be an invention or technology which has not been anticipated by what method? Number one, by publication in any document, or number two, or used in the country or elsewhere in the world. Before which date? Before the date of filing of patent application with complete specification. Okay. Now, what is a complete specification? What is a provisional specification? That I'll be talking in the second talk that I'll be giving today, just after this talk. So kindly bear with me for that. And after this, the patent office is going to check whether the subject matter of your patent application, whether it has fallen into public domain or not, or whether it forms or does not form part of the state of the art. Okay, so then you can say that yes, you have created something new, which means your invention is novel. Here, new meaning it has to be novel. So there has to be novelty, there has to be inventive step, there has to be industrial application. So these are the three things that which we have already understood, that law requires a invention to be called, to be recognized as an invention. So these are three things. Now, so let me count down. So what is the criteria of getting a patent in India? Firstly, it could be a product. Your invention should be a product. It could be a device, machine, instrument, etc. It could be a process, which includes any procedure, method, techniques, etc. Or it could be product by process. The next condition is that you cannot apply for multiple patents in one application. One single invention per application. Okay, so your one patent application should contain only one single invention. You cannot club 2-3 inventions together and claim one invention in one patent application. For different inventions, you have to claim different patent applications. So this is called the principle of unity of invention. Okay, and why this is done? This is done so that one person or one company, whoever is the applicant, cannot gain monopoly over multiple inventions. Okay, and also it gives greater scope of public to challenge the inventions. This is the reason as to why unity of invention procedure and principle is followed by the Indian Patent Office and also everywhere around the world. So the next test which my invention has to overcome is the test of novelty. That means I have to prove that it is a new invention. And I said it has not been anticipated by publication or used elsewhere in the country or anywhere in the world. Now, what is the test of anticipation that the Patent Office does when I make an application? So this is a legal test. What the Patent Office will do is that it will take the subject matter of your invention, whatever you have claimed, and it will run a background check whether the claims of your invention are matching with any other document, Okay, it need not be matching with only a patent document. Whether it is matching with any other document which contains features of your invention, because I said patents are given for features of an invention. So it will match the features of any other invention which is there already published in any other document, but not in a secret document. Okay, not in a secret document, which is published in any other document, and it will match them against the claims of your invention. And if there is a direct 100% match with one single document, okay, this is very important. The match has to be against only one single document out of all of them, and that single document, if read by a person skilled in the art, it will be sufficient for him to come to your invention and perform your invention. Then, if such an event happens, the Patent Office will say that your invention lacks novelty. So, what is the condition when I lack novelty? Is that whatever I have claimed in my invention is matching directly with the features of another invention which is published anywhere in the world on or before the date of filing of my patent application with complete specification. And if a person skilled in the art reads that other document, one single document, he or she can come and perform my invention. So then my invention does not have novelty. However, if such a scenario is absent, then I can claim that yes, my invention is new and it has novelty. After I overcome this test, so this is the first test that the Patent Office does. The second step, as we said, I we also noticed that my invention has to have a inventive step, because without inventive step, okay, I cannot have an invention. Now, what is the legal test that we use to evaluate whether my so-called invention has an inventive step or not? We use the test of obviousness. Now, I said I will just explain what is the test of obviousness. So remember, in test of anticipation, the background check was against one single document. Can we find one single document which contains all features of an invention? Suppose we don't find one single document, we find 5 documents in which my claimed invention is distributed in parts, part by part, but they are not in one single document. And if I combine these 5 documents, these documents may be, they are published documents, maybe patent, maybe non-patent literature, okay? It does not matter. And if I combine the readings and knowledge of all these 5 documents, then any person skilled in the art who reads these 5 documents jointly can come and perform my invention. Then my invention does not have inventive step. Okay, so this is the test by which the patent office will understand whether your patent application, so-called your claimed invention, even has an inventive step or not. So novelty is one single document, inventive step is mosaic of various documents. Okay, so after you overcome these 2 hurdles, which are the 2 most important hurdles that one has to overcome, then I should also be able to justify to the patent office that my so-called claimed invention is capable of industrial application, because it is a necessary clause for me to get a patent. Otherwise, there will be no patent. Also, my patent application should disclose the best method of performing of my patent, because if there are, say, 5 to 6 methods of performing my invention, okay, because for example, let us take a chemical process. Okay, chemical process has a product, and the product also has a yield. There is a percentage yield. So there may be 5 different methods by which I can get this product, but the yields in all of them are not the same. So generally, I have to mention which is the process for getting the highest yield. So I should disclose the best method of performing of my invention. And if I do not disclose this, I will not get a patent. Okay, even if I qualify for novelty, I qualify for inventive step, I am able to prove that there is capability of industrial application. Until my patent application in its written description discloses the best method of performance of my invention, I will still not get a patent, and I have to justify this. And one more very important aspect, before filing of patent itself, in fact, before even beginning your research towards a process or a product which has a high, which has or may have a very high intellectual property value in terms of patents, first one must understand, the scientist and the faculty must understand whether what I'm working on, whether it is at all patentable in India or not. Okay, so section 3 and 4 of the Indian Patents Act, which is there specifically in India, it tells you, section 3 will give you 15 categories of scientific work which cannot be patented in India, and section 4 will tell you that whatever is coming under the Atomic Energies Act, if your invention falls under that, it cannot be patented in India. Okay, so if you make an atom bomb, if you make something of a radioactive substance which can be used in the atomic, which comes under the Atomic Energy Act, can be used in the warfare technology and stuff like that, you cannot get a patent in India. Okay, and we should very well understand that this section 3, which contains, which we are about to see, contains around some 15 categories of invention. I will try to highlight some 10, 11 of them. So many of these categories actually are maybe patentable in other parts of the world, maybe in USA, maybe in Japan, maybe in Germany, maybe in China, but they are not patentable in India. Okay, there are multifarious reasons as to why such a thing has been kept in India. And so let us see what we cannot patent in India. Okay, so let's start. So, so first category is an invention which is frivolous or which claims anything obviously contrary to well-established natural laws. Okay, so for example, I am an inventor. I have claimed that I have invented a machine that makes energy out of nothing. If you just keep this machine outside, it will convert the atmospheric air into liquid air without application of any electricity, without any mechanical force. Now, can I get a patent for this? Obviously not, because I have claimed something which is contrary to well-established natural laws, because it violates energy conservation principles. Okay, so such inventions which are frivolous, absolutely rubbish, or which is claiming something contrary to well-established natural laws, cannot be patented in India. The second category, an invention, the primary or intended use or the commercial exploitation of which would be contrary to public order or morality and which may cause serious prejudice to human, animal or plant or health to the environment. If your invention is falling under this category, it cannot be patented in India. For example, I am a molecular biologist, I'm a microbiologist, and I have invented in my laboratory after 7 to 10 years of hard work, I have invented a gene. Okay, so the human cloning system. Okay, the human cloning system I have invented, and I want to patent this human cloning technology. Can I do it? Answer is no, because if this is given, it's a fantastic technology. There is no doubt about it. It's a huge leap in the scientific field. But the question is, should the government give you patent for this? The answer is no, because if this is given patent, then people will manufacture armies of people. Okay, people with unscrupulous ideas will put this technology to bad use. So this cannot be given patent. The third one is mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. So if you discover anything living, non-living, you will not be getting a patent. Discovery of a scientific principle. For example, Maxwell's laws of electromagnetic induction, Newton's laws of motion, Einstein's theories of relativity. No, these are will be termed as scientific principle or formulation of an abstract theory, and these cannot be given patents in India. Okay. Now the fourth category. This is a very interesting category, and this is very, very important for people who are doing research, specifically in biotechnology domain, in the virology domain, in the healthcare, the pharma, as well as chemical engineering domain, because this is a section 3D specifically dedicated to such areas of work. So it says if you're working in these areas, what you cannot patent in India. So there are a couple of things. You just see the orange words that I have highlighted. It says mere discovery of a new form of a known substance. Okay. So if there is a known substance, say carbon. Carbon is a known substance. Coal, charcoal is a substance. If you have a new form of a known substance, say I'm talking about allotropic, I have invented C60, Buckminster fullerene, or I have invented graphene, okay, which is also a nanoscale structure of the carbon or graphite. So new form of a known substance, if I am doing in the laboratory, it cannot be patented in India unless, of course, I can show to the patent office that my new form of a known substance, okay, there is absolute enhancement of known efficacy of the original substance. So if I can prove that my graphene, my Buckminster fullerene has enhancement of known efficacy which is not shown by pure charcoal or pure soot, then even though I have invented a new form of a known substance, still I can get patented in India. Okay, so this is one clause. Second clause, if my invention is mere discovery of a new property or new use of a known substance or the mere use of a known process, machine or apparatus, unless I can prove that such process results in a new product or employs at least one new reactant, I will not be able to get a patent. So I am discovering a new property of a known substance. So for example, graphite is known. Graphite was already known in the leads of pencil. And it was also known that graphite was a good conductor of heat and electricity. We know this from class 10. Okay, when the chapter on carbon was taught to us. Now, brilliant innovator as well as inventor makes, electrical wires out of this graphite and says that now I need patent technology because now I am being able to transform electricity through graphite. Okay. Now the question is, will he get a patent for that? The answer is very difficult to say because firstly, if it is for new discovery of it's a new property, okay, then he has to prove that this graphite wire that he is using in those wires, okay, employs at least one new product or at least one new reactant. Otherwise, he will not get a patent. Okay, so something like this. So be very careful about what you are working on when you're designing your research project in the very beginning, applying for grants. Please check section 3 of the Indian Patents Act, because while applying for a grant for a project, I'm sure the faculty and the research head would have something in mind that this is why I want to do the research. My end goal is to manufacture this or to get to this product or to come to this, develop this process. So please see whether the product or the process is coming under that section 3 of the Indian Patent Act, and if it is coming, how you can overcome that objection, because this is an objection that is going to come. Okay. Now the question is, I said it is the same. It is the same substance. Now, what will be considered to be the same substance? Because there will be a debate between scientists that this is the same substance, and somebody will say that no, this is not the same substance. So law has made it very clear what is the meaning of same substance under section 3. It says, for the purpose of this clause, salts, ester, ether, polymer, metabolites, pure form, particle size, isomer, mixture of isomers, complex, combination, so on and so forth, are all considered to be the same substance unless the patent applicant can show that his invention or this substance that he is claiming differs significantly in properties with regard to efficacy. So if there is a question raised by the patent office that you are falling in section 3, section 3 inventions are not patentable in India. So give us a justification as to how your new form of a known substance or your discovery of a new property or your use of a known process, machine or apparatus is not coming under section 3. So then you have to attack the questions of efficacy. You have to show to the patent office that it's a product or a process that implies one new reactant or gives rise to a different product. And unless you can show this, you will not be granted patent. So section 3D, very important, as you can see, for a couple of huge branches in science and technology. Okay. Then a substance obtained by mere admixture, resulting only in the aggregation of properties of the components thereof, or a process for producing such a substance. For example, I take, say, 5 different kinds of fluids and I mix them all together. I basically prepare a mixture, but the mixture does not have a characteristic property of its own. The properties of the mixture is nothing but the aggregation of the properties of those 5 components. And I am trying to claim the mixture as a invention and claim patent. Answer is no, because this is a substance obtained by mere admixture. So this is an example. Mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. Now, what is the meaning of this? Suppose I have 5, let's take electrical engineering. Okay. So inside, I have made a machine. Inside, I have put 5 components of a machine. If these 5 components of the machine independently function against each other or without the input of one component on the other and they independently work, then this is nothing but a mere arrangement or rearrangement or duplication of known devices. However, if the output of one of my component is the input of the other, or if the components are jointly working together, that means if one component fails, the other will also fail, then this is not a mere rearrangement or duplication of known devices. So then I will be able to overcome section 3. So this generally comes in electrical engineering devices and mechanical engineering devices problems, because the patent office would say, see, this is basically an invention of its own, this is working independently, that is working independently. So how are you claiming a patent? Because you have only put some components which are working independent. So this is how you have to overcome. Method of agriculture or horticulture definitely not allowed in India, because India is a farmer based country and we cannot allow patents for seeds and stuff like that. For that we do have the Farmers Plant Protection Variety Act, and we can claim protection, IPR protection there. Okay. Coming to the medical industry, okay, any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings or animals and plants, or to render them free of such disease, cannot be patented. For example, I am a brilliant heart surgeon, and I have invented a technique in which the heart surgery, which earlier used to take 10 hours, can now be performed in 5 hours with high accuracy. Now, as a doctor performing this surgery, because I have only invented that technique, can I go for patenting that technique? Answer is no. Because if such a patent is given to doctors or in the people in the medical industry, then they will monopolize it, and only very few people will know how to cure the patients if the patient faces a similar problem. So in the interest of the general public, okay, such patents cannot be given. However, the instruments that are used in the medical industry, for example, the artificial heart valve, the procedure to insert artificial heart valve, if a valve in the heart is damaged by a doctor, okay, by a heart specialist, cannot be patented. But the artificial heart valve can be patented by the company that makes it, because that is not something that is naturally found in nature. So they have to have innovation, invention in making that, and that is patentable. Okay. Then the next category, plants and animals in whole or in any part thereof, and other than microorganisms, but including seeds, plant varieties, and these cannot be patented in India. And as I said, there is Plant Protection Variety Act under which the IPR can be claimed, but you cannot have a patent for this. And if you can see, other than microorganisms, this microorganism has been left out. Why it has been left out suddenly by the patent office, by the India government? This is because this again comes in the specific domains of biological chemistry, immunology, because we require a lot of proteins for DNA recombinant technology, and we use microorganisms, we use plasmids, we use various kinds of bacteria to produce these proteins. So these microorganisms have been left out, but please understand, naturally occurring microorganisms cannot be patented. You cannot suddenly patent a virus or a bacteria which you have discovered. However, if you have the ability as a biologist, okay, to do genetic engineering on that, okay, it's a genetically modified microorganism, then that genetically modified microorganism can be patented. People who do cell culture, cloning, expression purification, they use what is known as plasmids, and these plasmids basically are genetically engineered viruses. So if something is genetically engineered, then that can be patented. But if that thing is naturally occurring, you cannot patent it, even though it is a microorganism. Then a mathematical or business method or a computer program per se or algorithm cannot be patented in India. So you write a very big program, so Windows, and you want to patent it. Can you patent it? Answer is no. So if you open Windows, it shows Windows, it is copyrighted to Microsoft. Okay, Microsoft doesn't own a patent. Why? Because computer program is coming under the purview of literary work under the Copyright Act. It comes under the Copyright Act in USA also, it comes under the Copyright Act in India also. So however brilliant program you write or algorithm that you write, it will come under literary work under copyright. So you can claim copyright, but you can never claim a patent. Okay. However, there are ways to claim computer programs like apps. So what is done is that in this case the program along with the instrument in which it works is claimed together in a very diligently written claim language, where it is shown that that instrument will never work without this code. So the code along with that machine is the key for going for a patent if you want to proceed in overcome section 3 for this. Otherwise, if you just submit a simple computer program or algorithm, it will be outright rejected by the patent office. So we saw around some 10-11 categories of inventions, even though they may be invention, but invention because they are satisfying the criteria of novelty, satisfying inventive state, they may have industrial capability. However, since they are hit by section 3, and section 3 specifically says inventions not patentable in India, you will not be able to get a patent outright. So this is the reason I said before beginning your research at the initial stage itself, not after 7 years, 10 years of research where you think that you have now developed a product or a process and let us see, we can go for a patent. At the end of the day, after 10 years, you may find that you are already hit by section 3. You should have never done that research in the very beginning itself. Okay, and market is full of such things. So please do these searches and please review these sections before you begin your research, so that at the end of 5 years, 7 years, your research not only gets published as a research article, but also you get a valuable IPR right in the form of patent protection. So it's very important here. Okay, so rights of a patentee and importance of patents. Why am I trying to go for a patent? What is my special privilege if I go for a patent? Firstly, patent, if you get a patent, has a much higher value than a research publication. Okay, so even if I have a Nature publication or a Cell publication, my patent, if I have a patent, that has an enormous higher value than the research publication. Okay, because I cannot prevent anybody from using my research publication, but I can prevent others from using my patent. Okay, my patent technology. Then, and how can I prevent? I can prevent them in 3 ways. First is from making or selling or importing that product or process in India. So I can prevent how? I can prevent others from making, selling, or importing the product or process in India based on my patent. So this is my right. So this is kind of a negative right. That means it's a preventive right. I can prevent others from doing these things with the technology that I have in my patent. Okay. Then monetary wise, why it is very profitable? See, research publication, you cannot sell your research publication. Nobody will buy it. But if your patent has technology, okay, which is not easily available, then as a patent right holder, you can license that patent and that technology for a limited or unlimited amount of time, whatever. It cannot be unlimited amount because of time, because your patent right is for 20 years, for a limited amount of time, and you can earn profit. And if somebody else is trying to manufacture a product or process through your technology for which you already have a patent, and you come to know about it, then you can get injunctions from the court of law against such patent infringement. And not only that, you can also claim damages or accounts of profits in case of this patent infringement is proved. Okay, so this is a huge amount of economic as well as legal right that is given in the form of patent protection, which is not available to you if you only have a research publication. Okay, so this is why the government of India in the past few years is striving so much so that the universities and the top research institutes in and around India, they invest a lot of time in getting patents, because otherwise, if your invention is not protected through a legal right, anybody can steal your invention and you cannot do anything because it is just a research publication. Okay, so these are the important rights of a patent, and this is why one should go for patents. Now, the question is who can apply for patents. So there are three categories of legal people, okay, who can apply for patents. First is the true and first inventor of the invention can definitely apply for a patent. Second is assignee of the true and first inventor. I'll give you an example of assignee. For example, Techno India University. So there is a group in, say, biological chemistry department who has invented something. Now all the faculties, I believe, have employment agreement with the university, wherein it is clearly stated in the IPR clause of the agreement. If you look back in your agreement, that all the IPR that is generated during the employment of the faculty will belong to the university. So the faculty has basically assigned all the rights of IPR to the university. So the faculty will be the inventor in the application, and the university, Techno India University, will be the applicant. So this is called assignee of the true and first inventor. So the faculty who invented is the true and first inventor, and Techno India University becomes the assignee and the applicant. Okay. The third category is legal representative of a deceased person who immediately before the death was entitled to make such an application. So these are the only three categories of legal people in India who can apply for patents, and these three categories can either be natural person or a small entity or a startup, and whatever is not falling under natural person, small entity or startup will come under the category called others. For example, universities will come under others. Companies which are not startup or small entity will come under others. Okay, so on and so forth. So this is who can apply for patents. Now, timeline. If I apply for a patent, generally what is the procedure that is followed, how much time it takes. So generally people start with filing a provisional specification, and within 12 months of that, something known as a complete specification has to be filed, which contains all and every information that you want to let the controller of patents know about your information. So this is the complete information. Okay, then after you submit this, within 18 months from this, on and after 18 months, there will be naturally publication of your patent application. And if you want to do it in an expedited fashion, it is now available. But if you do not do anything, still naturally it will get published, automatically it will get published. But for these 18 months, okay, your application will not be open to the public for viewing what you have applied for. Please understand this, that after the publication, your application will be made public. And why it will be made public? Because the government wants people in the country to understand and know that this is an application which has come for a patent. Does anyone have any objection or not? Okay, that is the reason the government makes it public. So this publicity happens only after publication, on and after 18 months. Then if somebody has a problem with your application, okay, somebody has an opposition, somebody has some grievance that no, he is not entitled to get a patent, then there are two ways. First is called pre-grant opposition, which can be done by any person. He or she comes before the patent office and through a notice gives pre-grant opposition notice that I have objection to this patent getting granted, and he or she can do this anytime before the grant of patent, but after the publication. Okay, so after publication and before grant of patent, pre-grant opposition can happen. Okay, if this does not happen, then the applicant should go for request for examination within 48 months from the date of application, which we call the priority date. The first document that you had applied for will be called the priority document. In very, very simple terms, to explain, to get acquainted with what is a priority document, there are other definitions under section 11. So request, then within 48 months of that, we have to go for request for examination. Now, unless you file request for examination, it will not be automatically examined. Publication will happen automatically, but examination will not happen automatically. So you have to make request for examination after publication. Then the patent office will examine your application and issue what is known as the first examination report, which we call FER. I have to report within 6 months of issue of this FER, and this 6 months can be extended by a maximum period of 3 months, not more than that. Then depending on my reply which are given to the patent office, there will be a hearing. Generally, there is always a hearing in 99% cases. And depending on the hearing, the patent office will decide whether they will grant my patent or they will refuse my patent. And after that, if it is granted, publication of grant of patent is done. Okay. And after, within 1 year from the date of grant of patent, within 1 year, any person interested can again apply to the patent office for what is known as post-grant opposition. So I told you there are two opposition stages. One is the pre-grant opposition, which happens after publication and any time before the grant of patent. And after grant of patent, within 1 year from that date of grant, one can have post-grant opposition. So this is generally how the timeline flows from the application till the grant of patent. Okay. So the pre-grant opposition, as I said, it can be made by any person, and this is done under section 25 subsection 1, post-grant opposition. It has to be done only by an interested person, and time limit is 1 year from the grant of patent. Now, types of patent applications. Okay, so there are generally 3 kinds of applications: ordinary, PCT, and convention. So whatever is not convention and PCT is an ordinary. Now, what is convention and PCT applications? Okay, so, and these 3 can also be again divisional application or a patent of addition. So let us just see in very brief what I'm talking about. What is divisional application? See, in the beginning when I started this talk, I told you criteria for getting patent in India is unity of invention. That means you cannot apply for multiple patents in one patent application, right? So one application means one invention. So if a situation happens that a person has combined knowingly or unknowingly more than one invention and has made a patent application, then if that person so desires himself on his own voluntary will or with a view to remedy the objection which is raised by the controller on the ground that the claims of the complete specification relate to more than one invention, that applicant can now file a further application in respect of an invention which is already disclosed in the previous application. And this new application is called a divisional application. So in order to keep the concept of unity of invention alive and prevent people from getting multiple inventions under one single patent, a divisional application legal procedure is kept. Okay. What is patent of addition? Patents of addition generally apply to modifications of the already existing invention. Okay. Patent of addition is not a new invention. Please understand this. So for patent of addition, there already has to be a mother invention, and if there is an improvement, okay, or modification of that mother invention, then, or which we call the main invention, then one can get patents of addition. And the time limit of patent of addition will expire with that of the mother invention. So if the mother invention is 20 years, and after 10 years of expiration of that 20 years, you have applied for a patent of addition on the mother invention, and you are granted a patent of addition, say, in the first year itself. So the validity of a patent of addition will be now 9 years, because 11 years has already gone by. 1 year has been passed for your this thing. So now the validity would be 9 to 10 years and counted from the date of your application. It will not be 20 years again, because it is an addition or improvement or modification of an invention. Okay. So this is something called incremental invention. Okay. Now we were talking about Indian patent system. Now I told you patent is a territorial right. Okay. So I am very happy that I have invented a beautiful machine or a beautiful drug which can cure a lot of disease, or I have invented a machine which can purify air within 10 minutes, the whole air in my home in 10 minutes. And now I have been granted a patent right in India. But I also want to get this intellectual property right in USA. I want to go to Japan. I want to go to Germany. I want to go to England. How am I supposed to do it? So to facilitate the international scientists and that innovation and technology reaches everywhere around the globe from where it has emanated, there are 2 routes which we call the international routes, and through these routes a person sitting in India can file for IPR rights in the form of patents, trademarks, industrial designs, GI also, and specifically I'll talk about patents. And sitting in India, I can file not only in India, but I can also file parallelly in many foreign countries. And how to do that? There are two routes. One is called the Paris Convention route. This Paris Convention was adopted in 1883. India is a signatory to that. So all the countries that have signed and ratified the Paris Convention Treaty in 1883, if you can take this route and sitting in India, you can file in any other country along with India also, and within 12 months you have to do this. Okay, so 12 months from the date of filing of complete specification, within 12 months through this route you can enter many international countries which are a signatory to this convention. So we call that entering into the national phase. Why national phase? Because each country has its own patent law, so you are entering the national phase of each country. But you do not have to run around in every country. Through one international route, you can do this. The second route is called the PCT route, called the Patent Cooperation Treaty, which was signed in 1970. India is again a treaty to this. Here, there is a little bit relaxation in the time limit. So after filing of the complete specification, generally 30 to 31 months. Okay. So from the date of priority, we will enter into the national phase. So generally, within 24 months of filing of complete specification, you have the right to enter into the national phase. So 31 months from the date of priority, or around 24 months from the date of filing of complete specification, or the PCT application. The PCT application should be a complete application. It cannot be a provisional application. It is equivalent to that of a complete specification. So once you enter this, and then you name the countries in which you want your rights to get enforced. Say I name 10 countries, and then after that I will be able to enter within 34 months. Okay. So these are the two international routes. So there is nothing to worry that sitting in India, how will I get a patent in America? If an American company comes to know of my technology in India, they will steal that technology, or they will adopt that technology, and they will market my product in America, but I cannot claim a right. Yes, there is a way. Similarly, a person sitting in USA also can enter India in a similar fashion. So that is why many research heads of the companies, the R&D of many companies which is there in Europe, in USA, when they launch products in India, they enter the PCT route in India and also claim a patent right in India. So this was the timeline I'm saying. Now, coming to monetization of patents. Okay, so why these are the rights that I can have, I can enforce. Now, once I get a patent in India, okay, so how can I utilize that patent? The first is licensing, as I said. So I can go for licensing, I can go for cross licensing, and I can also go for assignment of sale. And why is I am being able to do this? Because Government of India has given me an exclusive right for 20 years that I can prevent anybody in India from manufacturing, importing, or making or selling that technology which I have patented. So I am the sole owner of that technology now, because government has given me right, and it is a technology which is required in the market. So other people say that, okay, let's not make this product again, let's not invest into R&D. You already have a patent for this, so please give us license, and I can charge for that license. Okay, so I can also do cross licensing. So if I'm doing licensing is generally of three types. One is the exclusive license. Exclusive license is I am an inventor, I have a patent, and there is a company which has approached me to grant me license to use the technology of my patent. If I give an exclusive patent, license right to that company, it means that whatever rights I'm giving to that company, to that extent, even I cannot use that technology, even though I'm the patent holder. So exclusive right gives to the right holder, okay, gives a right to the exclusive licensee to use the technology in the patent, even to the exclusion of the patent holder. Okay, so these exclusive rights are generally very costly, because you are not giving it to anybody else in the market. The person or the company to whom you will give that right will be the sole player. Okay, then I can give non-exclusive right, where I tell a company that no, I will not solely give you right. There are 5 companies, and I need this technology to reach out to the market as much as possible. So I will give you non-exclusive right, meaning that I will give the right to you, I will give a part of right to somebody else, I'll give third right to somebody else. So all of you can have non-exclusive right to manufacture and market that product. So this is called non-exclusive license. And the third is end user license called EULA. Okay, end user licenses generally you would find in your computer science related inventions, computer technology, where, and this is very important because suppose Microsoft has a technology, and Microsoft also is works in collaboration with many small companies. Okay, so they have R&D collaboration with many small companies which provide certain technologies to Microsoft, which Microsoft incorporates in its products. Okay, so generally what these big companies would do is that they will say, okay, see, this is the mother technology that we have. You want to use this technology and you want to make this product, you do it. But during the process of R&D on our mother technology, if there is a new IPR that gets generated, then the end user license or that patent or the right for that new technology will belong to Microsoft itself. It will not belong to you. So this is one way. Sometimes the companies will say, we will jointly own it. Microsoft will also own 50%. Your company will also own 50% of any new IPR that is being generated, because you have also invested your time and money. Okay. So this is called end user license agreement, generally prevalent in the electronic and the computer science industry. Okay. Okay. Then compulsory licensing. What this is how I was telling you can make money. You meaning the patent right holder can make money. Now what will happen if there is a patent right holder who has got a patent and who is withholding the patent and not giving license to anybody? Neither is he manufacturing anything. Okay, neither is he or she going for industrial application, neither he or she is allowing anybody to get license also. So once he or she has got a patent, she is keeping completely mum, completely closed. So what will happen then to prevent such a situation? Because as I said, patent right is given so that people in the country can get facility and benefits of your invention. If you do not give your invention to the society, then there is no point in granting your patent by the government. So to avoid such a situation, the government of India, okay, has compulsory licensing, which is ingrained in section 84 onwards in the Indian Patents Act. So this is very important to understand. What is compulsory licensing? Okay, so it says that at any time after the expiration of 3 years from the date of grant of patent. So compulsory licensing can only happen after 3 years. Okay. Then any interested person can make an application to the controller for grant of compulsory license on a patent on any of these following grounds. What is the ground? First ground, the reasonable requirements of the public with respect to patented invention has not been satisfied by the patent holder. Number two, patented invention is not available to the public at a reasonable price. Or number three, or okay, that the patented invention has not been worked in the territory of India. If that person is able to make out any of these three grounds, then the government will approach the patent holder and say, and first ask, basically throw a notice that why are you not giving any license to anybody else? If you are not giving, you are also not making anything, but your invention needs to reach out to the market. So what the government will do, government will acquire license of your patent. Okay, so this is kind of a forcible acquiring, you can say, not legally allowed, because you are preventing the market to get benefits of your invention. You have become an extremely selfish person that I have invented, I will not allow anybody. I have got a patent, that's it. Such a thing is not allowed. Okay, it is spoil the harmony of the economy, because if every inventor who gets a patent gives the invention to himself or herself, then how will the society get benefit of the invention? Okay, so to prevent this, we are doing this. Now, so section 100 gives power to the central government to use your patented invention for the purpose of the government. Section 102 gives legal right to the government, central government, for acquisition of inventions and patents which the government thinks is necessary for the government. And if you are aggrieved that why the government is doing this to my patent technology, I have the right. The only remedy for you is to go and approach the High Court under section 100. Other than this, you cannot do anything. You can go to the High Court and put down your grievances in the form of a petition that you are not happy, or this is the reason that you think that the reasons given by the government for acquisition or of your invention is unjustified and illegal and unlawful. Unless you can do this, okay, the government has the full right to acquire your patents. So this is the procedure of compulsory licensing, very important in case of vaccines. Okay, in this scenario, in the COVID vaccine scenario, we did not have this condition where only one company is manufacturing and it is not allowing any other company, because government has already stepped in the beginning. But if there is a condition where, for example, so Nepal today, Nepal gets infected by some deadly virus, and Nepal does not have that economic as well as scientific technological infrastructure to make a vaccine for that, say, virus. However, that virus has a vaccine which has already been developed in India, also patented by a company, so say a pharma company based in India. Then first, Nepal government will ask India to help. The India government will approach the pharma company that please we need 1 lakh or 2 lakh or 10 lakh vials of the medicine. Now if that pharma company says no, I will not give because I have spent a lot of money and research in making this drug. Only if you can give me this much amount of money, I will give, I will start manufacturing, I will not give. Then government will say, okay, I will take help of the Patent Act. It's a patented invention, I will acquire an invention. If you have a problem, go to High Court. Okay. So this is done to safeguard the interest of the public. So law is very beautiful in our country. It's very complex, but it also has remedies for the benefit of people. But unfortunately, most people use law in a very, unscrupulous sense nowadays for causing hurt to others, which should not be done. Always remember, law is for the society. Law is for the needy. It is not the greedy. And our Patent Act and IPR, other acts which are there, copyright and everything, specifically, harbors this idea that law is for the needy, not the greedy. You cannot be greedy. If you are greedy, then there are sections which will cut down your greediness. Okay. Now, once now we have understood on what I can get a patent in India, I cannot get a patent in India, what is an invention, what are the legal formalities or the legal criteria for my invention to be claimed as an invention. If I get a patent, what are the economic benefits that I can get? Okay, if I'm not sharing my patent for the benefit of the mankind, how the government will come and acquire. Now, if I want to open a company, okay, because nowadays youngsters are opening a lot of startups and MSMEs and everything. Now the question is, why suddenly I want to open up a company? I have patents, I have patents, and or maybe I am in the verge of acquiring licenses of patents from certain people who have patents, and I want to open up a company. Now the question is, why should I open up a company? Why should I open up a startup? Why should I open up a small scale or medium price or medium enterprise? Okay, this is because with the Make in India initiative, the government has given a lot of relaxation in the procedures and in the technical formalities, the legal formalities that you require to frame these companies, and also there is a huge amount of tax benefit also. Okay, so this is why the youngsters of today, and I really appreciate their enthusiasm, which we did not have in our times when we studied, because these acts were not there. These facilities were only not there of opening a startup and things like that in terms of innovation. Okay, so the legal scenario was different some 15-20 years back actually. So small entity, what is a small entity? First we must understand what is a small entity and what is a startup. Please do not be under the idea, especially for people who want to open startup, be it faculty and especially young people like who are completing their final year BTech or final year MTech and everything, that just because my company or I open up a company which deals with innovation, it is a startup. No, it is not a startup. Just because I have opened up a company which even does not deal with innovation, which deals in the service industry, people frequently call, we have a small startup company. No, it is not that. Startup is a legal word. And what should be the criteria for a company? Okay, company means what kind of companies can qualify as a startup, that I'll say. What is the legal criteria that needs to be made by this company to qualify as a startup is a clearly written legal condition, and you have to follow that condition. Just because one opens any company dealing with anything, and because your company is small, it is not a startup. Or just because young people, 22 to 25-year-old people are opening that with 10 people in that company, it is not a startup. Okay, so please let us understand first legally what is a startup, what is a MSME, what is a small entity, so that when we decide to frame a company, open a company with the patent technology, use the technology, try to make a product or a process, apply innovation, make a product which is commercially marketable in the in the market to gain profit. What kind of company is best suited to me, and where do I qualify? Okay, because there are big companies also like Sony, there is Microsoft. Are they startups? They are not startups. So they are also dealing with innovation. Your company is also dealing with innovation. So What is the difference? So let's see. So first, let's look at the the definition of small entity. What is a small entity? Small entity is a entity. It's a, I should say, a legal entity, business entity. You can say it's a legal business entity. Okay, which is involved in the manufacture or production of goods, and an enterprise where the investment in the plant and machinery does not exceed the limit which is specified under section 7 and clause A of the MSME Act 2006. So micro, small and medium scale medium enterprises development act 2006, which is called in short the MSME Act 2006, the maximum limit of investment in plant and machinery, okay, if it does not exceed that limit, then your company becomes qualified to be applying as a small entity. And if it is in enterprise which is not in involved in manufacturing and production but in rendering of services, so there can be two kinds of so there can be two kinds of enterprises. One is enterprise which is involved in manufacturing and production, and second is enterprise which is involved in rendering of services.
Sir, we can't hear you. Hello?
Equipment, which is specified under MSME Act. So this is how the small entity is defined under the patent rules. Okay, small entity is not defined under Patent Act. It is defined under Rule 2FA of the patent rules. Now let's come to what is a startup. As I said, any company that deals with innovation or invention is not a startup. Okay, so what is the legal criteria of a company that has to be met for it to qualify as a startup and apply? So first is that more than 10 years have not elapsed from the date of incorporation or registration of that company. This is clause number 1. And all these clauses have to be parallelly satisfied. It's not either or. It's all and. Okay. So firstly, not more than 10 years have elapsed from the date of its incorporation or registration. Clause number 1. Then turnover for any of these financial years in these 10 years cannot exceed 100 crores. So if in the 5th year the turnover exceeded 100 crores, then from the 6th year, you are no more a startup. Okay. So please understand that first the 10 years criteria, then in any of these 10 years, your turnover cannot exceed 100 crores, and your company should be working towards innovation, development, deployment, or commercialization of new product, processes, or services, which is driven by technology or IPR. So these are the 3 conditions which have to be parallelly satisfied by any company, okay, to be called a startup. But this is not all. Apart from this, there are 2 more conditions, which is given there in the proviso clause. In law, we call this as proviso clause whenever it is written, provided that. So you have satisfied all these 3 conditions. Now there are 2 more conditions. So what is the first condition? Provided that any such entity formed by splitting up or reconstruction of a business which is already in existence shall not be considered as a startup. Okay. So this, why is this been done? I said there is a 10 years criteria. Now your company was already in existence 5 years before. Now for the first 5 years you did not deal anything in technology. You were a service provider in the industry. Now after 5 years you suddenly get to know that there is patent technology. There is a lot of profit in patents. It's good for the community and science also. So you start acquiring patents and you make a huge R&D. And now you go for startup registration. Can you do it? Answer is no, because your entity was already there in formation. So you say, okay, I'm breaking it up. We are 2 brothers, we are breaking it up into 2 companies. Answer is no. Till the government will not recognize your company as a startup. Okay, so this is another condition. So even if you have satisfied the first 3 legal conditions, if you are falling into any one of this proviso clause, you cannot be a startup. What is the second proviso clause? It says that provided further that the mere art of developing of products or services of commercialization
Your voice is not audible.
Sir, we seem to have lost you again.
okay, just let me know. Yeah, am I audible now?
Yes, sir. Yes, sir. Yes, sir. You are audible.
Is the slide on startup highlighted?
Yes, sir. Yes, sir. Yes, sir. It
Okay,
is.
okay. So you see, I hope I've been able to understand that just mere opening of a company which is dealing with patent or dealing with technology without any patents is not a startup. Startup is a very critical thing, okay, and it's very important that that the youngsters today please understand who are trying to open a company in the form of startup, and because startup grants are given by government, we have IPR cells, we have technology innovation cells in big universities like Techno India, which help people to open startups. So before opening the startup, please understand whether you at all legally qualify as a startup or not. Okay, because once you open, then you will be in an ocean of soup as to how you should function. Okay, so now that we have understood what is a startup and what is a small scale industry in MSME, now I want to open a MSME. Okay, now I have a choice whether to open a MSME or whether to open a startup. On what is the choice dependent? See, specifically, it's a choice which an individual has to make. Okay, so first let's see what is an MSME. We have seen what is a startup. MSME, as I said, there are two kinds of sectors. One is the manufacturing sector, the other is the service sector. So if you're in the manufacturing sector, then there are three kinds of divisions of your company: micro enterprise, small enterprise, and medium enterprise. What is micro enterprise? Micro enterprise are the ones in which there is investment of less than or equal to 25 lakhs in plant and machinery. Small enterprise between 25 lakhs but not more than 5 crores, and medium enterprise is more than 5 crores but less than 10 crores. Okay. See here in MSME division, in the manufacturing sector, there is no criteria that your company has to deal with innovation, patent, technology, IPR, right? It only deals with the amount of investment that you have made in your plant and machinery. So there is a difference in way of categorization of MSMEs as well as the startups. Okay. Number two, if you are in the service sector, not in manufacturing sector, then what is a micro, small and medium enterprise? Micro enterprise would be one in which the investment in equipment does not exceed rupees 10 lakhs. Small enterprise is between 10 lakhs and 2 crores, and medium enterprises between 2 to 5 crores. Okay. So if you want your enterprise to be registered, then you will have to use the Udyog Aadhaar facility to go for MSME registration process. Okay. Now, as I said, business entities which are eligible for registration of startup and MSME. There is a lot of confusion which I found among many young people who said that let's open a startup. So they approach the government, they approach the Minister of Corporate Affairs saying that I want to open a startup company. Startup company is not a company by its own entity. It is a recognition that is given by the government to a company, okay, which satisfies the legal conditions of that company to be qualified as a startup. Please understand, I cannot directly register a startup. Okay, so what are the kinds of business entities which are eligible for registration of startup and MSME? First is sole proprietorship. This is the easiest and the most simple form of business. Proprietor, and the the business runs in his name. However, sole proprietorship can qualify for MSME, but it cannot qualify for startup registration. Okay, the other three companies, one is the private limited company, which can be incorporated under the the Companies Act 2003, the limited liability partnership. Okay, LLP, you must have heard this name, LLP. Now LLP is a very interesting concept which has been in use in India, I think since 2009, if I'm not mistaken. Correctly, please correct me if I'm mistaken by in the year. And this has a joint characteristic of a company as well as a partnership. So that's why it's called a limited liability partnership. It's very easy to open. There are lots of less hassles that one has in a company. So most of the people, youngsters and many other grown-up people also, initially nowadays incorporate LLP instead of a private limited company. And you can also open a plain partnership firm under the Indian Partnership Act. So if you want to register as a startup, firstly you have to either open a private limited company or a LLP or a partnership. Then you have to follow the legal criteria that is laid down for your company to qualify as a startup. Then you can apply to the government of India that please, I want to register my company as a startup. You cannot directly form a company called startup company. Okay. And apart from this, if you want to open a sole proprietorship, and you want to register for MSME, that is done, but sole proprietorship is not qualifying for startup. Okay, so once you have qualified, then you go to this website called DPPIT recognition, and it says in the orange, get recognized. And what is DPPI? It's written on top, Department for Promotion of Industry and Internal Trade. So this is the department, DPIIT. We will give you the recognition that your company is now a startup. Okay, so you have to go and register here. You have to provide all your information that they're asking. It's a big form. It can be filled up. It's a very easy form. It's a big form. So government will analyze the data, and if they find that the data is matching the criteria for your company to qualify as a startup, then you will get your startup recognition. Then after that, you can start getting benefits of your company getting registered as a startup. I will tell you what are the benefits of MSMEs and startup. Similarly, if you want to go and register in MSME, you have to go to this website, and you can register as MSME. Okay, so for MSME registration also, the same procedure is followed. You just need your Aadhaar card and everything, and fill up everything. Government will analyze your data, and if they find that yes, your investment meets all the criteria under the MSME Act, you will be given MSME status. Okay, so please understand, you again cannot, like a startup, open a MSME company. Your company has to be registered first, and then it will qualify as a MSME. Okay, now what are the benefits of a startup? Instead of opening a normal company, why should one start with a startup? So there are many benefits. I have tried to highlight in short the first 10, which I thought is very important. Firstly, from the day you have got your startup recognition from the government of India, there is tax holiday. Means first 3 years no tax of the company. It's a very big relief. Then you have exemption under Section 80 IAC of Income Tax Act, Section 56 of Income Tax Act, Section 54 GB of Income Tax Act. Then if there are it's a very new company, okay, government tenders. Generally, if you look at tenders, government tenders, they would ask tenders from companies which are not startup or MSMEs, which have to be having certain standards, say 5 years of experience or minimum 10 years in the field, or such proven ability to do the work. However, these government tenders are mostly, okay, and 99% in terms of science and technology or service industry are exempted, and gives a very less criteria, relaxed, much less criteria for startups, because startup itself is valid for 10 years. Now, if you as a government say to get this tender, you need 10 years of experience, then no startup can apply ever. Okay. So startups and MSMEs, since they are generally given for the youth to frame new companies and get India going. Okay. So there is ease of application for government tenders. So even if you're a startup, you just start 2 years in the market, you can still compete with your competitor who is 15 years in the market. In case of government tenders, in case of private tenders, this generally does not happen. They have their own rules. Okay. Then you have easy access to government funds. So when government came up with this Startup India initiative and came up with this everything, so government allotted rupees 10,000 crores for 4 years. Okay, so 2,500 crores each year for startup grants. So you can get these grants each year. 2,500 crores was allocated by the central government to help build and ease and proliferate the growth of startups and help the young people to get into the industry at a very early stage, and get the Make in India, so that you are a creator of your job and you do not have to run for job. Okay, you should be job maker, not the job doer kind of a thing. So that is very important concept. Then if you are a startup and you want to apply for a patent, okay, then your patent registration fee is just half of what an entity like a big company or a university will pay. So at present, last year 4th November 2020, there was an amendment in the patent act, and now the registration fees for an individual, a startup, as well as a small and medium scale industry, okay, all three are the same, and they are very low. Okay, however, it is different for that of a company or a university or something like that. Then you have reduced fee for registration of trademark. And please understand that whenever you open up a company, there are labor and environmental laws to which your company has to comply with. Okay, so if you are a startup, the government has provided that the moment you get startup affiliation, you are self-certified compliance of 6 labor laws and 3 environmental laws. So these are the very big 10 facilities which the government is offering you for harboring of technical inventions, for proliferation of technology, so that your product or process can reach the market, so that you can do your research, get a patent, start a company of your own. Do not depend on multinational companies for your employment, stuff like that, or to compete with multinational companies, even to give, you can even sell or license your technology to multinational companies who have higher capability to take your invention to a greater platform for the greater good of the mankind. So all these things to proliferate and help and facilitate these things, the whole patent act, the this relaxation in this criteria, this rupees 10,000 crores allotment, relaxation in the income taxes and framing of the companies, all this has been done by the government, and which is a fantastic era and fantastic time for people who are into the science and technology domain to work on innovation, and not means pure research which will only be lying there in some research journal. Okay, so try and do something which can come into the market, and you will also be benefited, the country is benefited, you can get recognition, and you can also prevent others from forfeiting and copying your invention, okay, which you cannot do if you only have a research article. Apart from this, also publish research article on your topic. There is no harm for this. Now, this is the last slide. The benefits of MSME. So there is priority lending by the bank. Okay, you can have collateral-free bank loans. Generally, I think it is till 10 lakhs. You can get a collateral-free bank loans. Otherwise, if you go for a loan to a bank, they will say that you have to keep something collateral, maybe your house or maybe some money, maybe some jewelry, whatever, which is appropriate collateral for the amount of loan you're taking. But for MSMEs, I think it is still 10 lakhs where the government is providing collateral-free bank loans if you are MSME qualified institution. Then you have protection against delayed payments from customers. You have exemptions from Income Tax Act. You have concession electric bills. If you are into the service or manufacturing industry, if you have gone for ISO registration, then there is reimbursement from the government for this amount of money that you spent in ISO registration. Again, just like startups, you can also be eligible for government tenders as an MSME. Even though you're a small entity, not been into business for long, still you can apply for government tenders. And just like government had invested rupees 10,000 crores in 4 years for startups, it has also various schemes. It has more than, I think, 20 schemes. If you go to the MSME website, they have a lot of schemes in lot of areas, because it's manufacturing service industry. It's a huge industry that runs the government economy. So there are a lot of schemes in lot of industries, especially also for women. Okay, so go and check it out. And similarly, like for patents and trademark applications, there is reduced fee if you are an MSME. And in case of overdraft facility by the bank, there is exemption in the interest rate for overdraft facility. So there are benefits of MSME, there are benefits of startup. Now, depending on the amount of investment you want to make, you can choose either you want to go for MSME or you want to go for a startup. It's specifically your company is not dealing with innovation and stuff, not technology, but into the manufacturing sector only and service, go for a MSME, because there the criteria has nothing to do with innovation and IPR. It is criteria is something to do with the amount of investment you have made in your business. Wherever your company is dealing with a innovation based criteria, you are trying to into heavily into R&D and stuff like that, then it's better that you go for a startup rather than the MSME, because there the criteria is IPR, invention, technology, and it is not dependent on the amount of money. It is dependent on how many years you have been into the market and what your company is doing. Okay, so that's all as far as from my part is concerned. Thank you very much, and I think I took a little bit of time. I exceeded my time, but I think since today is the first day on this lecture on patents, and I wanted everyone to clearly first understand the concept of patents and the various criteria that one needs to have a patent, and just doing science and technology will not help you, and to understand the other legal domains. So thank you.
Thank you very much, sir. It was indeed very informative. It will take some time, I guess, to
Yes.
absorb all this. There is a question by me. I am somebody who always takes the unfair advantage of the anchor. So my question comes first. If you could come out of the screen share, sir, it would be
Yeah,
better.
just a minute. Just a minute.
Also.
Uh, should I? How am I supposed to escape? No. Am I out of the screen share mode? Just a minute. Can you just tell me how am I supposed to stop share? Yeah. Okay.
Yes, sir. Right. So basically, my question was just a simple one. You did talk about if the technology, if the algorithm as well as the equipment goes
Yes.
together, then there can be a patent. So my mind just went to the Kindle instrument. Is that patented, sir?
The we have to check, ma'am, because I cannot specifically outright comment whether it has been patented or not, because I have to do what is known as a patent search for that, and we have to first see whether that instrument is patented in India or it may be patented in abroad also, because as I said, many of the patent criteria which are there in India which cannot be patented under Section 3, many of them can be patented in USA. So it may have been patented in USA, but it is not allowed in India. So that may be the case. So we can anybody can search it. People can search it right now in the who are the other attendees. Okay, there are like more than 100 attendees, I guess. So anybody can search on the internet and find out patent for Kindle instrument, like ma'am is saying, and you can see.
And the thing is that because these instruments are, there's these specific instruments being given for these educational online education portals as well. And there is the Zoho instrument also being given. So that's why maybe because those are very similar yeah, by nature, that they are a tablet which does some particular task.
Yes. Yes.
So yeah, that is why I asked it, sir. But yes, definitely we will look into this. One
Actually, if you're talking about a tablet, okay, now tablet would be a different instrument. Okay, now a tablet is basically it's a computer. It's basically a computer. Okay, it's a computer in a nutshell. So inside the computer, please also. Okay, I forgot to say something during my talk. For the people who are doing electronics engineering, okay, who are building circuits, who are dealing with microprocessors and stuff, today you have built the Pentium processor. Okay, Pentium processor is patentable, but the moment you put it on a Vero board and you frame a circuit, okay, because your computer can only work when you have circuit where you have various kinds of processors, resistors and so on. Question is, can you now patent this semiconductor Vero board technology? Answer is no. Okay, that is not patentable because that will come under designs, and we have a specific act in India which deals with the semiconductor design. So you can get registration under that. That is also an IPR right, but you will not get a patent.
right, sir. Right. That actually clarifies it. Okay. Good. Good. That's excellent, sir.
I forgot to say. Thank you for the question. Yeah.
Thank you, sir, for answering it so beautifully. Just hitting the nail on the head. And yeah, there is actually an answer already. So the Kindle application is patent filed by Amazon Technologies in 2010. Wow. So this actually led us to gaining some knowledge about it. This is excellent, sir. So there is one question here. Are there any, this is by Kaushik Pal, are there any schemes available for MSMEs and startups with respect to IPRs?
See, when you go to this website, these two websites that I just highlighted in my talk, the DPIIT, okay, where you go for the startup registration, and the MSME website. So if you go to the MSME website, there you will find on top toolbar there are a lot of schemes of the government. Okay, so you can see all these schemes, because first you have to understand whether you're into the manufacturing sector or whether you're into the service sector. Because a person who is manufacturing electric bulb cannot be the same person who is selling agarbatti, but both will come under MSME. Okay.
Okay.
Provided your investment is not exceeding the amount which is there in the act. If you can manufacture bulb within 5 lakhs, nobody is stopping you. Manufacture and start MSME. Okay. But if you want to become global leader, then you will form General Electric company.
Right. Right.
So then you do not qualify as a startup, because you're more than 10 years plus your investment is more than 100 crores in a year. So automatically you cannot qualify as a startup. This is the reason as to why universities generally do not qualify as MSME or startups, because university can never be a MSME, okay? And university is always in existence for more than 10 years. So university cannot apply for a patent as a startup.
Right. This is an important point. This is actually an important point.
Because whenever I give talk and with my clients, sometimes the university people say they are misled by certain people saying that no, we will jointly apply with a startup. So the director of the company opens a startup, and with that the university becomes co-applicant. So there will be deduction of fees. The answer is no, because whenever your university is a legal entity which will come under others category. Okay, neither an individual, neither a startup, neither as a MSME. So it will fall under others category. So this I will show what is the patent filing charge now in my second talk, which is the last slide. If you are an others category and you are applying for a patent as an applicant, and your co-applicant is an individual or your co-applicant is a startup or a MSME, you still give the same charge as others. You don't give the charge as startup. So if a startup is giving 1600 rupees, just because you have now a co-applicant with your startup, you will not be giving 1600 rupees. You will still pay 8000 rupees.
So there's one question in the chat box, and that's again an interesting question. Is that you said herbal raw material is it cannot be intended. What about isolated phytoconstituent, phytocompound? Is it possible for applying patent?
Okay, so this is, I'm a biotechnologist. This might be the most biologically active metabolites. Can you just tell me which is this one, no? Dr. Dhubajyoti Sen, right?
Yeah.
Under section 3D, right. Under section 3D, herbal raw material cannot be intended. What about isolated phytoconstituent? Is it possible for applying for patent? So the first thing is that if it is an isolated compound from a natural product, okay, if it is an isolated compound from a natural product, or you can make that compound in a chemically modified process. Now there are two ways of making a biological stuff. One is by a chemical modification using chemical tools in your laboratory. If it's in the pharma domain, you can use DNA recombinant technology, or directly isolating your product, your desired product from the plant or that animal in which it is present. Now, if it is directly isolated, okay, then you cannot get a patent for that because it is only a mere discovery. Number one. Number two, you cannot say that this has inventive step or an invention, because you cannot prove enhanced efficacy. You can only prove enhanced efficacy with respect to the original compound. And here you're trying to get a patent for the original compound, so you will not get a patent. However, if you can now chemically modify your phytoconstituent after extraction or by some other method, and your new phytoconstituent has enhanced efficacy much more, maybe 1000 times more, okay, than the original phytoconstituent which you had extracted from the plant or the animal, okay, from the plant, then probably you can overcome section 3D. But otherwise, naturally, if you have extracted, chances are very, very less, because you are not doing anything. You are only doing an extraction procedure under biology. So extraction procedure under biology, where you are getting a natural product, I don't think there is a high chance of patent. It's a very difficult stuff.
So I think we will have to move on to your next talk, because we are a little short on time now.
Yes. Okay, there's just one question that somebody asked. Post 20 years, because I had said patent invention protection is for 20 years. So somebody has asked, after 20 years, what could be the fate of the patent? Is there any chance of repatenting? Answer is no, there is no chance of repatenting. After 20 years, your patent is available to the public. Anybody can make it, anybody can import it, anybody can sell it. Okay, the three rights that you had to prevent people from manufacturing, importing, and selling the technology of your patent, all those three are non-existent. So anybody can do anything with your technology, because now it can come out in the market. Now it will not be an infringement. Okay, so that is the technical answer, legal answer. So if now anybody does anything with your patent technology, you cannot claim infringement. So that is the fact. But for 20 years, you have enjoyed your monopoly, right? So if you are not being able to do anything for 20 years, the government doubts you will be able to do anything in the 21st year, actually. Okay, so that is the thing. So that's it for this topic. Should I go on to the next topic, ma'am, directly?
Yes, sir. Yes, sir. Please.
Okay. Can you just give me 5 minutes break? I need to have some water. Just 5 minutes break.
Absolutely, sir. I mean,
Okay. Thank you. We'll just meet after 5 minutes. Okay.
Right, sir. Right.
Okay. Thank you so much.
Ashok sir, any instructions from you in the meantime?
Momita, please engage the participants somewhere, okay? If Ashok sir can say something, or Ravi.
Actually, we have got a lot of new ideas. We have got a lot of new ideas. Especially, we have got ideas for startup. So that ideas for startup and ideas for MSME. So we can think over it that whatever in the design or whatever we make, whether it can be implementable. So those things can be done. And if any participant is having any specific question, he can discuss, and some participants also can answer also. If there is any specific question,
Yeah, they will probably have to type it. Are they?
no. Yeah,
they
they have to
cannot
type
talk.
it.
They will have to type it.
They have to type
So
it. Yes.
if there are any other questions, yeah, there's some questions coming in the chat box as well. In the question answer. Yeah, Shantanu Chakraborty's question actually, that in case of an academic research project leading to patent, what are the funding agencies? This is a question. This was not seen then. I think after the second presentation, then the speaker can answer it, or if somebody else can answer. Any idea of the
I can give my idea. See, that is probably he is asking that who will give the initial funding for applying for the patent, isn't it? That question may be for who will give the initial fund for applying. Initial for applying for the patent, that fund requirement is very small. Okay, that I don't think that any government will give. It has to be done by the.
No, sir, the academic research involved. Maybe some research that will go on, and then they will come to a finding which will be applied as a patent. Then
the output of the academic research, if you have to apply for patent, that I feel it is to be done by the institute itself, and the amount is not high. So initially because as long as you are working in the laboratory of the institute, so the patent will be in the name of the institute.
Right. That is the answer. Correct.
In the name of the institute, because it is done under the supervision of institute, or it is done by a team of faculty.
Mainly the questions till now, the typed questions that are there.
I'm back.
Yes, sir.
Yeah.
Sir, you can start.
I'll share my second slide.
Yes.
Okay. Is it visible?
Yes, sir.
Okay. So now that we have a preliminary idea about what Indian patent system is all about, what we cannot and we can patent, what are my rights, what I can do to prevent others if I have a patent right, how I can make money out of my patent, how I can benefit from the use of my patent technology, get into a product for innovation, help the country and everything. Now the question, this is a bit more technical talk, which is called the basic concepts and guidelines on drafting patent specification. Okay, how am I supposed to draft a patent application? This is all that I'm about to say. This is a very this is going to give you a preliminary idea that what should go into your write-up. Okay, so please first understand that patent application write-up is something which is similar to that of writing a research publication, but in many aspects it is completely different. Okay, and this is a very specialized kind of writing which has to follow certain legal rules if you want your patent application to be granted, and you need to meet the criteria. Okay, so the next slide I'll go. So just a recapitulation, that these are the 9 conditions that one needs to keep in mind while making a patent application, and when you satisfy this condition, then the government of India is going to grant you a patent. Okay, and always please remember section 3 and 4. In section 3, 15 categories of inventions are mentioned, which per se cannot be directly in any way patented in India, unless of course you are being able to give justification to the patent office as to why you do not fall under section 3. And section 4, definitely not energy inventions which relate to Atomic Energy Act. Okay, now specifications. Okay, now specification is basically a technical term. It's a legal techno-legal term which is used for the draft application for a patent. Now there are 2 kinds of specification. One is called a provisional specification and the other is called a complete specification. Okay, so let us first understand what is a provisional specification. So it's a provisional specification is usually filed by the applicant to establish priority of the invention. In case, I'll explain you what is the meaning of priority. Priority is a legal word. Okay, I will tell you what is the meaning. To establish priority of the invention in case the disclosed invention is only at a very conceptual stage and a delay is expected in submitting the full and final details of the invention, and no patent is granted on the basis of a provisional specification. Then we have another specification called complete specification, where this is the document in which all the details of the invention for which the patent protection is desired are disclosed. The complete specification has to be filed, okay, within 12 months from the date of filing of provisional specification, and this 12 months cannot be extended in any way. If you cannot file your complete specification within 12 months, your patent application will be deemed to be abandoned. Okay, you cannot extend this 12 months as of now. Okay, now why to file provisional specification? When no patent is granted on the basis of provisional specification, why should I suddenly file this? Because there is something called a priority. Now let us take an example, very simple example. I am trying to make a machine. I'm trying to make a coffee vending machine. Okay, I have all my ideas intact, and I know that the coffee vending machine with the designs and the technology that I'm researching on and I'm trying to implement is definitely going to work. But what I want to do is that I do not want to spend time, because who knows, in this coming 6 months, anybody from India elsewhere may file a patent application on the coffee vending machine, because I cannot be under this impression that I am the only person in India who, or in the world, who is working on the coffee vending machine. There may be other people. Okay, so to prevent other people from getting this right, what I do is that I file a provisional specification with my preliminary work on the coffee vending machine, and within 12 months of that, I file my complete specification which contains all the details of the coffee vending machine that I am trying to get patented as a technology, as an invention. Now, in my previous talk, I said there is publication after 18 months from the date of application. So when the publication will happen after 18 months, publication means now your invention application for a patent will be available to the public. Anybody in India or abroad can see that this person has applied for a coffee vending machine. Okay, this is his invention, this is what he has written, these are his claims, these are his diagrams. All this will only be open to you after 18 months, after the publication. But you know what is the date of application? Date of application is when you filed your provisional specification. So this gives you an edge over your competitors who are working in the same field. So say on 1st of January 2021, you have filed a provisional specification. Then you will file complete specification within 12 months. Say on 31st of December 2021, you have filed your complete specification. Now, somebody in the month of May 2021, on today's date, filed another application. You do not know that this person. He is from another part in India. Okay. He also is working on the coffee vending machine. He has also filed a prior application date, at least 5 months prior application date, because he applied on 1st January 2021, and this person is applying today. So at least 5 months before you have applied. So in your publication, when it will happen, then your application.
Sir, actually, you are not audible.
So we can't hear you.
You can't hear.
Is it gone on mute? Oh, I think some network issue.
I think Dr. Saha is joined again.
Momita, what happened? Sir, উনি কি disconnect হয়ে গেছেন নাকি?
Actually, উনি আবার join করেছেন। উনি আবার he has joined again. I could see that he has joined again, but he is not able to connected. We are not able to connect him through audio or video. He has joined. He was disconnected, then he has joined again.
Rupal is there.
Yeah,
Yes,
Rupal-
ma'am. I'm calling him.
Check what is the problem.
Yes, ma'am. Yes.
Yeah, he has joined from another device.
Ma'am, he just lost connection. He's reconnecting. He's just trying to reconnect.
Okay.
I would request everyone to please allow us a couple of minutes for him to reconnect.
ये चैटे एकटू लिखे दाओ चैटे एकटू ये করে দাও হ্যাঁ
Yes, ma'am. Sure.
Am I audible now?
Yes. Yes.
Sorry,
You are
I
audible.
completely lost connection for 2-3 minutes.
Yes. You are audible now. But
Yes.
when you come to again, the screens are more.
Yes. Can the screen be seen now?
Yes.
Okay. So it shows specifications, right? The screen.
Yes. Is it possible to zoom in full
Just
screen? Thank you.
So as I was saying, provisional specification, a complete specification. Why file a provisional specification when I cannot get a patent for that? I will only be getting a patent for complete specification. That is because provisional specification, the date of filing of the provisional specification will be considered to be the date of filing of my application. And if I get a patent, my 20 years will be starting from the date of filing of the provisional specification. Number one. Number two, I can prevent anybody who has filed any patent application after my provisional specification filing, okay, and once my patent application gets published, I can go to the patent office against that other applicant and say that he or she has filed an application which is very similar or exactly similar to what I have filed, and since I am the first applicant, I have filed before him, so my application has a priority, and so you will go for a pre-grant opposition. So this is the advantage of filing a provisional specification. And this should only be done if you are not ready with all the data at present, but you want to prevent others also from coming into the market, and you want to prevent others from getting a patent on the lines on which you are trying to get a patent technology. However, if you are ready with all your data, then there is no point in filing a provisional specification. Please directly go for filing a complete specification. Okay. So these are the two kinds of specifications. Now, what will be the contents of this specification? There is a little difference in the in content. Both these contents, the first is title of the invention. This is common to both, whether you file provisional or complete. You have to write the title of the invention. You have to write the field of the invention. I will tell you in brief that what should be written in title, what should be written in field. Okay. For the time being, just know that these are the headings that have to be given. So one is title of the invention. The second is field of invention. Third is background of the invention or prior art. Fourth is object of the invention. Fifth is summary of the invention, which is not required in provisional but mandatory for complete. Then brief description of the drawings, if any. And if there is any drawings, you must give brief description. For complete specification, you must give detailed description of the drawings relating to your invention. Okay, be it a product or a process. Then description of the invention, and this should be in a detailed manner in the complete specification so that the patent examiner, controller understand exactly why you have applied for the patent. Okay, that you have to write in a very meticulous fashion that where is the inventive feature in your invention, why your invention is novel, why you are not hit by section 3, okay, which is the best method for working of your invention, what is the industrial application. All these you will have to write in your written description. And then your patent should end, the patent application description, which we call the written description, should end with what is known as claims. Okay, you will be given patent right for your protecting your invention based on the claims. Okay, I will tell you what are claims. So, but claims are not required to be written in provisional specification. Okay, so this is the reason that you do not get a patent for provisional specification, because provisional specification does not contain claims, and you get patent for the claims. And abstract, which is required for complete specification but not required for provisional. So in provisional, you do not need to write abstract, claims, and detailed description of the invention or summary of the invention. Okay, so these are the 4 things that you need not write, but all these things rest need to be written, and for complete specification, everything that I've written needs to be written. Now, what will I write in the title of the invention? Can I write anything? No, there is a legal method of writing title. So the title of the invention should reflect the main art of the invention. It should be precise, meaningful, and should be normally within 15 words. And a title can be used for more than one invention. So if it is a product, you must write what exactly is your product. If it's a process, you should write what exactly is your process. Okay. So a process for manufacture of this, or a product, or an electric bulb like this. So as you keep on seeing patterns, and as you will hear talks in the next couple of days, what I'm saying today will be of more relevant to you once you start seeing patent applications. So this is what is needed to be written in the title of the invention. Then field of the invention. So field of the invention should describe the scope of the invention. Okay, and the subject matter of the invention on which it relates. Subject matter of the invention is given in section 3. Whenever a patent examiner will talk about subject matter, it means he is trying to see whether you are falling under section 3 or 4, because section 3 and 4 tells you what are the subject matters that cannot be patentable in India. So you must specifically write in your field of invention that this is the subject matter, so that patent examiner understands that you are outside section 3. Otherwise, there will be an objection. Okay, and you have to overcome that. So basically, you have to write subject matter and scope of your invention, and you should write it in a crisp and clear enough so that the examiner can easily understand the nature of the invention and classifies the technology according to its generation. So if it's because when it goes to the patent office, depending on whether it is a chemical or electrical invention, different examiners are appointed. Controller is appointed. Okay, an electrical invention is sent to a patent examiner who is specialist in chemical biology, will be of no use. So you must write your title and field of invention in a very specific manner, so that the patent office understand who should be, or the group of examiners to whom it should be sent. This is the idea of writing the field of invention. Background of the invention. Okay? This is very similar to what you write when you write in a research journal as introduction, that what has happened in the world before you did this work, what this person has done from Germany, what that person has done from USA, and it's so on and so forth. But there is a little bit difference in the way you write this background and prior art in patent applications to compare to that when you write it in a normal research publication. Here, when you're writing background of the invention in a patent specification, you have to specifically first understand what is the domain of technology that you are working in. Number one. Number two, you have to understand and make the patent office realize through your writing in background of the invention of prior art, that what was the previous technology traditionally or available in the market or non-available in the market, which is there in the published material on or before the date of your application of patent, which relates to your invention also. Relates to your invention meaning not your invention, relates to the field of your invention. Because you may be working in a field where other people have other inventions also. Then you will have to highlight this is very important. Why we write? Then you will have to highlight the drawbacks and shortcomings of these prior art inventions. Why you have to highlight the drawbacks? Because you are saying, please give me a patent for my invention because it has inventive step and it is novel. Correct? You remember? Now, how can your invention be novel and have inventive step if it is not being able to overcome the drawbacks and hurdles associated with the other inventions? So this is why, that is where your novelty and inventive step will come in. So this is why you will have to highlight what are the disadvantages and drawback and shortcomings of the previous inventions or previous articles that are published, and this is the reason of writing background of the invention. Okay, so it is not just like this work has been done earlier and this work has been done earlier and I'm just trying to add on that work. You will never get a patent. Okay, your work has to be maybe in the same field, but it has to solve a certain technical problem through the features of your invention, which the earlier inventions or earlier publications highlighting that field of work and invention could not solve till now. And that is why your invention is novel and inventive. Okay. Then object of the invention. What is your object of the invention? Your object of the invention is to solve the problem in the prior art. Very simple, one line answer. So object of the invention should be written in such a fashion so as to give an idea to the patent controller that these were the problems in the prior art which I just wrote in the background, and my object of the invention is to solve these problems in the prior art through these features of my invention. So this is what you have to write in object of the invention. Okay. Then statement of invention. This describes the exact novel features of the invention, because there is a difference between inventive step and novelty. I hope you remember how the patent office investigates novelty. It will match the features of your patent with the already existing document on or before the date of your filing, and it will try and get one single document which contains all the features of your invention. If it is able to find it, your patent application does not have novelty. If it is able to find not one document but 5 documents, joint reading all of which will enable a person skilled in the art to come and perform your invention, then your invention lacks inventive step. Okay, so this is how the two tests of novelty and inventive step, tests of anticipation and tests of obviousness respectively, are carried out, and your statement of the invention should describe the novel features of your invention. Okay, so that it is very clear to patent office that it is a novel invention. Okay, then summary of the invention, what you will write. Summary of the invention describes a broad overview of the invention and thus provides a structured understanding of the detailed description and claims of the invention, which you will write in the specification. Okay, so it describes the overall invention. Okay, and generally the summary of the invention would be the independent claims of the invention. That is what is the normal working methodology in the patent fields, which we do. Generally, the independent claims of the invention, we rewrite that in a more broader fashion, in a little bit more broad overview as the summary of the invention. Okay, so you see these headings that we were talking about, there is specific legal requirement as to how you should write. But when you're writing the publication in a journal, there is no such legal requirement. You may write accordingly, right? But that is not the method that you can follow while writing a patent. So we have come now to summary of invention. Now, brief description of drawings. So if you have number of drawings or at least one drawing, then you should say what the figure is about. Okay, so that is called the brief description of the drawing. So you should specifically mention that what is the figure that you are trying to highlight, and that figure that you are mentioning should be related to the technology or the invention that you are trying to patent. Okay, it cannot be an arbitrary figure. Please try to make a figure which will help the patent controller, the patent examiner, in understanding how your invention works. Okay, so just do not create any figure. Create a figure from which the novel and inventive features of an invention can be understood. Okay, it may be 2 figures or 3 figures, but those figures should highlight the novel and inventive features of your invention. Okay, this is how you should create drawings and figures. Then detailed description of the invention. What you should write, the detailed description will describe in detail what the invention is in detail and how it is made and used. So you should also write the best mode or best method of performing of your invention, which I said is a criteria for getting the patent. You should also give detailed description of the figures and the way in which the so-called claimed novel features and inventive features of our invention works. Okay, so that it should be sufficient for a person skilled in the art to perform the invention by developing the necessary technical know-how. So the patent controller imagine that patent controller to be a person skilled in the art. So a person skilled in the art, if he sees your patent application, okay, after your patent is granted, he or she should be able to perform that invention which you have described in the patent. Your description cannot be such that you have got a patent and now I try to make that technology, okay, or work that technology out in my laboratory. I took your patent application, but when I'm trying to work out the figures that you have given, the description that you have given is not sufficient for me to work that patent out, then there will be problem in your application. Okay, then there will be opposition, then there will be a lot of problems. So it is your duty to clearly mention out in the detailed description how your patent technology works, how your claimed patent technology works, how your invention can be worked out in the best mode, and what are the conditions, what are the necessary requirements to work that out, and everything should be written. Okay, so you cannot leave out loopholes, you cannot leave out people to experiment on those areas like that. Okay, you cannot be leaving out loopholes for somebody else to work on this based on your figure. Your figure should give the exact same results as you have got. So this is how to write the detailed description of the invention. then your patent application should end with what is known as claims. And as I said, claims are very important because claims have to be written based on the written description that you have written. Written description consists of the detailed description of the invention, the summary, the title, the brief description, okay, the object of the invention. Everything that you have written will end in what is known as claims. Claims are the essence of a patent, and claims are legal in nature. Everything has a very important legal aspect because the claims define the invention in which the inventor holds as his exclusive property and has the right to exclude the others from make, use, or sell or import that product or process in India. Correct? This is why you can get a patent. So if you want an exclusive property right in the form of patent right of IPR, then you have to very, very specifically define through writing in the process of claims to the patent office as to what are the novel and inventive features of our invention, which together when they work perform the invention. This is the claim, and you will be given patent rights for claims. Each claim has a priority. Please remember, priority is for the claims. Okay, when I say priority is on the date of filing a patent application, that is because generally the claims are with that attached with that application. However, there may be priority associated with different claims. Okay, so remember one thing and keep in mind there can be different priority for different claims. Okay, so the claim specifies the scope of ownership. This is why you should draft the claims in a very, very meticulous fashion. It is not written in the Patent Act as to how claims will be drafted. It is also not written in the Patent Act that what should be there inside the summary and this and that. This I am saying out of our years of practice and professional experience, which we do when people come up for patenting, facilities. So claims are of paramount importance because it specifies the scope of legal ownership of that intellectual property in your name. You will have an exclusive patent right in the form of patent holder. Okay. So during claim drafting, the choice of words used in the patent claim should be dealt in a very great understanding and thought. Okay. I will tell you what are the different kinds of claims, what should be kept in mind. So claim drafting. Okay. What are the important points that one has to keep in mind? So firstly, each claim should be a single sentence and should be very clearly worded. Okay. Number two, each claim should be very precise and without unnecessary repetition. Third, rights are given to claims only and not for matter described in the complete specification. So your claims should have reference to complete specification, but your claim cannot be something outside of your complete specification. Okay. So whatever you have given in the written description in the form of title, summary, object, background, and everything, your claims cannot go outside that. Please remember, you cannot claim something that you have not written in your written description. Okay. So that is the boundary, and you have to understand what will be your boundary. Because depending on the boundary that you claim, and if you get the right from government, that will be the boundary of your exclusive right. So you have to understand very clearly and very precisely what you want to claim as a right. And each claim is evaluated on its own merit, and therefore, if one of the claims is objected, it does not mean that the rest of the claims are invalid. Okay. So this is why you should understand how to write each claim in a very nice fashion. Then, how to do this? So first, you must figure out all the essential features or elements of your invention that you want to claim, right? Because I said patent is given for features of an invention. So find out what are the essential features. Then find out why those features are novel and why they have inventive step. Then your duty is to write these inventive step and novel features in the form of claims. Okay, very simply put, you must be able to make the patent office understand that these are the novel and inventive features of my claimed invention for which I need patent right, and so I'm writing them in the form of claims. Okay, and so when you write claims, you must first start with the broadest claim of your invention and then progress to narrow claim. Okay, so then you must start each claim on a new page, and number each claim using Arabic numbers starting with 1. When you start claiming claim 1, which should always be the independent claim, I will tell you what is a dependent claim, independent claim, multiply dependent claim, we will come. But first, now just understand what you have to keep in mind while drafting a claim. You should start with these words I or we claim, and then you should start writing claim 1, 2, 3, 4. Okay, you must write this I or we claim, and each claim should have there is a syntax of writing a claim. Just like there is a syntax in English grammar, you just cannot put any word after any word. Similarly, while drafting claim, there is a little syntax. It says that each claim should consist of an introduction, linking word, and a body. We will see what I mean. Okay. Then the first claim would be the independent claim, and the subsequent claims would be called the dependent claims, which are linked so as to form a single inventive concept. Why I said single inventive concept? In my previous talk, I said your patent application can contain only one invention, right? Your patent application, if granted, will be given for only one invention, because unity of invention concept needs to be followed. So you write this independent claim and write dependent claims which are dependent in their features on the independent claim. But if I take as an examiner all the dependent and independent claims together, I should still be able to form a single inventive concept, that is one single invention. It cannot form 2, 3 inventions. Then we'll have to go for divisional application. Okay, then I will have to file divisional application, I have to take out, I have to file new application. There will be a lot of trouble. So please, this is a very, very important tool to remember, that the dependent as well as the independent claims together taken as a whole should still form a single inventive concept to maintain unity of invention. Okay. Then there is how many claims can I draft? Basically, there is no restriction to number of claims, but after 10 claims and 30 pages of written description, you have to pay extra charge. I will tell you what is the charge. Okay. So generally, patent application, the standard fees that I will say at the end is for 30 pages of written description and 10 claims. Anything over 10 claims, so per claim you will have to give a charge, and any written description above 30 pages, so per page you will have to give a charge. Okay. So generally we try to complete within 30 pages and 10 claims. Okay. And your, as I said, the claims must be supported by written description, so that when the patent examiner looks at claim 1, he should be able to find the features that you have claimed in the written description. Okay. Anything cannot be missing in the written description. You also cannot claim anything outside the written description. Okay. Okay. Now, so these are the things that you have to keep in mind even before you start the drafting of claims. Okay. Now, there are various kinds of English transition terms which has a legal meaning. Okay, these are simple English words to say, but when written in the context of patent drafts, they have a considerable amount of legal meaning and can give a considerable difference in opinion in the way your application is interpreted legally for grant of patent. So first, these terms are called transition terms. Okay, the first is comprising of, and the second is consisting of. Let us today understand the legal meaning and the difference between comprising of and consisting of. Okay, in generally when we write English literature, most of the terms times people use these comprising of and consisting of interchangeably, just like people use innovation and invention interchangeably, even though they are different. Here also they are completely different legal meaning. So let us see what they are. These are called transition terms, and they are used to link sentences together. So use of transition term in patent drafting is for linking different elements together. Okay. So let us see what is the meaning of comprising of. So this term called comprising of means including the following elements but not excluding the others. Okay, so this is an open transition term allowing, for example, a method claim to cover infringing methods that include additional steps. Synonyms are including, having, containing, even varying. Okay, so comprising, when you write, it gives you space and scope to include other things in the same family that you have not claimed. So generally people write comprising of. So if you're claiming 1 or 2, 3 techniques, other techniques which follow similar thing would get included in comprising of. So this is a smart way of drafting claims called comprising of. But when you write consisting of, then whatever you have written under consisting of, you will get patent right only for those. So suppose I have written 3 methods, method consisting of 1, 2, 3. I will get only patent for 1, 2, 3. If there is a method 4, which is even similar or whatever, which I have not claimed, I will not get, because I have written consisting of, and consisting of is a closed term. So legally, comprising of is a much broader open term, and consisting of is a closed term. Okay, so people try and generally avoid writing the word consisting of unless they are very, very sure. Okay, so whenever you claim a composition, for example, you're claiming a composition in a drug, in a pharma, you're claiming composition in a chemical engineering. Composition, generally always people write comprising of, unless of course it is a straightforward compound in which there cannot be any variation in the percentage of the individual components, then you can write consisting of. For example, sodium chloride consists of sodium and chloride. You have to write consisting of. You cannot write sodium chloride comprises of sodium and chloride, because sodium is an alkali metal. There are other alkali metals also, but other alkali metals when joined with potassium will not give sodium chloride, common salt. Potassium chloride is not common salt. So when you write sodium chloride, it has to be written consisting of sodium chloride, because it is a closed term. Okay, but if you are using a perovskite structure, if you are using a composition, okay, you are making thin films, you are into the thin film industry, surface physics, and you are making thin films for use in the industry, commercial industry. In thin films, you may change the composition, because generally people who have worked with thin films, you will find that the composition is like 1 minus x, 1 minus 0.5x, like that. That x is something that you can change. So there you will write comprising of, because you do not know what x is, you will give a range for x. So you will write comprising of. Okay. So I hope the legal meaning of consisting of and comprising of is understood. Then, if you write consisting essentially of, what does it mean? This slightly has a broader version of consisting of and allows the addition of elements that do not affect the basic and novel characteristics of the invention. But you cannot keep on adding all elements. Consisting essentially of is little bit broader than consisting of, but not broad enough as comprising of. Okay, so people generally use either consisting of when they are very sure that nothing needs to be changed, and when they are working in a range of compounds or range of products or range dealing with range, they will write comprising of. Okay, so as to make it broad. Now, as I said, there is a structure of the claims. It has an introductory part, it has a linking part, and a main body. So this is an example which I've given. So a patent claim is composed of 3 parts. So first will be a preamble or introductory part. Then is the main body and the linking part. So what should be the preamble? Preamble should tell whether it is a product or a process. Okay, your title of the invention as well as the preamble of your independent claim should clearly tell the patent examiner what you are trying to patent. Is it a product or a process? Like here it is written a method for promoting. Method is a process. So immediately patent examiner knows that I have claimed a process. So a method for promoting weight and fat loss in an individual in need thereof. Okay, so this is the introduction and preamble. Then I am using a linking term comprising of, and then I write whatever is the novel and inventive features of my invention in the main body. Okay, so first you write the preamble where you write what you are trying to claim, method or a product, whatever it is, and why it is used. Then you write the linking term comprising of, consisting essentially of, and then you write what are the novel and inventive features of your invention in the main body of the claim. So this is the basic structure of legal structure of writing a independent claim. Now, we have been talking about independent and dependent claims. So what are they? So independent claim is one which covers all the significant features of the invention. Okay, and it is the first claim which reflects the generally whole picture of the invention. It is the claim that contains the novel and inventive features of your invention. So this is why it is the first claim, and it is called an independent claim. There may be more than one independent claim in your patent application also. Depends what you are trying to claim. There can be more than one independent claim. In general, there is if it is a product, there is only one independent claim. If it is a product by process, then there are 2 independent claims, one for the process, one for the product. The rest are all dependent claims. Okay, so this is the significance of independent claim. So let me give you an example of a very simple claiming. So look what I have written: a method of preparing an electronic device This is my preamble. So I am trying to patent a method. This method is for what? Is for preparing an electronic device. So understandably, the examiner understands that this should be the work of either an electrical engineer or it should be can be instrumentation, okay, or design. So he has already understood to which group of examiner it has to be sent. And then I write comprising of. I have used the linking words. Then providing a metal containing substance, converting the metal containing substance into a non-stoichiometric, non-equilibrium crystalline nanomaterial, so on and so forth. These are what? These are the methods in which I perform the invention. I am trying to highlight the novel and inventive features. Okay, so this is how you should try and write a claim, or whenever you see a patent, this is how you should try and interpret the claim. Figure out what is the preamble, figure out what is the linking portions, and then see what he has claimed in the body as novel and inventive features. Okay, otherwise it will be very, very difficult for anybody to understand what he is trying to claim. So this is the method that is generally used by the patent office. Okay. Then what is a dependent claim? The claim which depends on a claim or several claims is called a dependent claim. So generally the subsequent claims of an independent claim are dependent claim. Okay. So anything that depends on an independent claim is called a dependent claim. For example, the method of this is how we write. Claim number 1 is an independent claim. Then claim number 2, the method of claim 1, wherein the nanometal comprises a metal. Okay, wherein the nanomaterial comprises a metal. In claim 1, I just wrote that my method will work on a nanomaterial. In claim 2, I am saying what are the nanomaterials on which my method will work. So that will now be a dependent claim because metal is also nanomaterial. Okay, so this is how you write dependent and independent claims. Then multiple dependent claims. Okay, so what is multiple dependent claims? These claims refers to two or more previous claims in the alternative. Okay, either or alternative. How? For example, an apparatus of claim 1, okay, or claim 2, further comprising of, and you write like this. Okay, so it can be either or in the alternative. It cannot be and. Okay, it cannot be the apparatus of claim 1 and claim 2. Then it will not be multiple dependent claims. It will you have to be written in the fashion either or, and it should be in the alternative. So an apparatus according to claims, if you write an apparatus according to claims 1-1 to 3 is unallowable. Why? Because I have written 1 to 3. 1, 2, 3. When I write 1 to 3 with dash inside, it means that I am taking all. There is no alternative that I am providing. But multiple dependent claims can only work in alternative, either or. So this will not be allowed. Okay, you write 1 to 2, not allowed, 1 to 3, not allowed. But 1 or 2 allowed, 1 or 2 or 3 allowed. Okay, and it must specifically point to the previous claims on which you are depending. So an apparatus of any of the previous claims is unallowable if you write. You must specifically write on which claim you are depending for writing claim number 3. Are you depending on claim number 1? Or are you depending on claim number 2 or claim number 3? You must specifically mention 1 or 2 or 3. You just cannot write an apparatus as mentioned in the previous claims as mentioned above. No, that is not allowed. Okay. So this is how multiple dependent claims are written. Generally, it is not very much seen in the industry, in the literature, but it is allowed. Okay. People generally only write independent and dependent claims. Okay. Now, doubly dependent claim. This is not allowed only. What is a doubly dependent claim? For example, if I write an apparatus of claims 1 or 2 made by a process of claims 3 or 4, this is a doubly dependent claim because your apparatus can be made either from claim 1 or 2. Okay, your apparatus can be chosen either from 1 or 2 and can be made from a process of either 3 or 4. So your process 3 can be dependent on apparatus 1 also, 2 also, or your process 4 can be dependent on your apparatus 1 or 2 also. So this becomes a doubly dependent, multiply dependent or doubly dependent claim, specifically a doubly multiple dependent claim, to be very precise. So doubly multiple dependent claim. So first is multiple dependent, then doubly multiple dependent. Okay, so 1 or 2 and then again 3 or 4. So there are 2 ors. This is not allowed. Okay. Okay. Then what are the kinds of categories of claims? Okay, so these are the independent, dependent, multiply dependent, double multiple dependent claims. These are the criteria of claiming. These are the kinds of claims that we write. These are independent of whether you are claiming a product or a process or whatever. Whatever you are doing, you will always have to write an independent claim followed by dependent claims like that. Or your patent may not contain any dependent claim also, but it has to contain at least one independent claim. So please understand, your patent application should contain at least one independent claim, whether it contains any dependent claim or not. Okay. Then if you are trying to patent a product, you can have a product claim. Okay. So claim which claims the actual product of the invention is called a product claim. For example, products could be a chemical compound, compound is for pharmaceutical, composition mixtures, alloy, food, drink, etc. Wherever there is inventive step, there is novelty, and it is a product that basically you are making, you will have a product claim. And then you will find a method, this is an apparatus or a compound, okay, a composition comprising of, this is how you will write a product claim. Okay, polymer, something like this. Okay. However, if it is a process I said is like a method or a procedure. Okay, then you will write it like this. For example, a bio-assisted method for the treatment of hydrocarbon contaminated soil employing a blend of so and so. So this is how you write a method claim. Method claim will come under process, because methods are always processes. Okay, so you will have to write depending on what you are trying to claim. And if you are claiming a product via process claim, then you will write one independent claim for the process, and you will write one independent claim from the product that you have obtained through that process. It cannot be a product which you have obtained from another process. Then you will have to file another patent application. It has to be the product from that specific process only. Okay, so then you will write two independent claims. Okay, this is what I said. This is a product by process claim. So then you will write two independent claims, one for process, one for the product. Then apparatus claim. So what is apparatus? Apparatus would include machines, devices, electrical circuits, electrical circuits which are outside the purview of the Semiconductor Technology Act. Okay, Protection of Semiconductor Circuits Act. Okay, electrical circuits outside that. Okay, electronic circuits. Then computer-related items, hydraulics, for example, mechanical inventions, nanotechnology-based inventions. You're trying to make a product, drug delivery system. These are all. If it's a drug delivery system, then basically that is a drug carrying apparatus which is going inside your body and delivering the drug. So it's an apparatus claim. Okay, and the way this apparatus works would be a method claim. Okay, so you can have both. So you have to clearly first understand while doing your research. In fact, which I was saying, in fact, while writing the grant of your research, while deciding the topic of your research, first please go through the Patent Act and understand whether are you trying to do a research or trying to begin a research or applying for a grant, which even if you succeed in the research, you will never get a patent because you're hit by Section 3. First understand this, try to do a research which is outside that. If you're interested in getting a patent, getting into industry, related products, earning from licenses of your patents. Number two, please try and understand and figure out what is the end product of your research that is going to be after 5 to 6 years. Are you trying to make an apparatus? Are you trying to make a product? Are you trying to figure out only a process for making a product? Or are there any chances that there can be multiple methods to come to that product that you're trying to make? Then how are you going to prevent your invention from being used by other people? So these are the things which, in my opinion, a researcher, a scientist, team leader should start thinking while writing the grant of the research article itself. Because anyway, when you do the research, if you're keeping all this in mind, you will anyway have a very high level journal publication in science. You don't have to worry about it. But parallelly, you will also get patent right protection if things go right and you are maintaining the criteria of getting patent in India. If you qualify for those, you will also get a patent apart from getting a very good publication. But if you do not do this, and at the end of 6-7 years of your research, after you have developed a product only, but now you suddenly contact a patent professional that I have developed this product in my laboratory it can be, I think, we want to apply for a patent. Now, this person, this patent specialist, does a prior art search. This is what we do. First, we will do a prior art search to see with what is available in the market in industry form as well as in literature form before you want to file your patent. Many of the times, what the problem that academic researchers face is that after these 6-7 years of hard work, where people did not take into account the patent act and the criteria and what I have said, I'm trying to impart knowledge on, and they just did the research, they did good research, they got a journal, but they could never apply for a patent because somebody else had already applied for a patent. On later, after prior search, we came to know that not only there is a patent, that patent has even expired in the market and people are freely making that product and there is no infringement. So he was only limited to publishing a small scientific publication in a journal, but his dream of applying for a patent is primarily extinguished itself in the domain of during the stage of prior art itself, because when I see that it is already patented, then there is no use filing a patent and wasting money of the client, because anyway he will not get, there will be huge objection. So please do this search and this things while beginning your research itself. Okay, then people okay, this is a claiming method, pure structure. This structure, please do not think that this structure that I'm referring to is a chemical structure or an engineering structure or a design structure. This is a pure structure, is a chemical, is a legal word. Okay, it is a method of claiming. So when will we say that it is of pure structure? A method of structuring claim where the part of an invention A is structurally linked to part B. Okay, so for example, very simple example, a switch connected to a lamp. So switch is an independent invention, lamp is an independent invention. Now you're connecting both through a wire, which itself is also an invention. So this is where innovation comes in. There are 3 different inventions. You connect all of them. You're an entrepreneur. Okay, you have a startup and or you have a manufacturing unit in the form of MSME, and you acquired the patents through licensing of the guy who has patent for switch, of the guy who has patent for electrical wire, and the guy who has patent for electric lamp, and they have worked independently. And now as an entrepreneur, you connect all of them, you get a bed switch with a lamp, and you market that in the industry. So this is how innovation takes place. So such kinds of things are called pure structure based claiming, where structurally an invention is a part of an invention A is related structurally to part of invention B. Then we have another kind of method of structuring, which is called structure plus function. For example, a switch for controlling a signal to a lamp. Okay, so this is a structure which controls the function of another invention. For which I said, a switch for controlling a signal to a lamp. Okay, then means plus function. This is a method of structuring claim where the part of an invention A is an element for achieving the part of invention B. For example, means for signaling with a lamp. Means is that electrical signal arrangement that you will have, which will enable the signaling method so that you can light that lamp. Okay, so this is means plus function method of structuring. So these are generally happening in electrical engineering, mechanical engineering part, because here one part is connected to another part, and then only then the whole machine forms. Okay, so these kinds of things we generally encounter while doing mechanical, electrical, electronic inventions and computer related inventions also. And after you've done all this, your complete specifications should end with an abstract. Unlike where we write in a normal research publication in scientific journal, we write abstract on top, right? Generally 150 words. But here in patent application, we will write abstract at the end and in a completely separate page. Generally, limit is 150 words. And the abstract and what should be the content? The abstract should be drafted in such a manner to make it reflect the technical field of invention with the existing technical problems and the solution to work on such problems through your invention. This is how your abstract should work, so that a person skilled in the art, if he reads your abstract, he should be able to understand that this is a technology which you have patent on, and in the previous technology, these were the problems which your invention through these features has worked out. So this is the abstract which you have to write meticulously in and around 150 watts. Okay. Now, this is all about drafting, and if you are filing for a patent with complete specifications, then there are certain important forms that you have to fill up and submit along with the application. First is Form 1, which is application for grant of a patent. This is very important. And the, for example, if it is a university is the applicant, whereas the researchers in the university, be it the faculty or his students, PhD students, who did that invention in the laboratory, they are the inventors. Okay. So Form 1 says who is the applicant, who is the inventor, how many pages is your description, how many claims you have given, what is the address of the inventor, this and that, and everything. Okay, this is a very big form, and it's called application for grant of patent. Form 2 is the form in which you have to draft your provisional or complete specification. Form 3 is, I said, patent is a territorial right. Okay, and I also told you that there are two international routes by which you can go for patent. One is the PCT route, the Paris Convention Treaty, the Patent Cooperation Treaty, and the Paris Convention. These are the two routes, Paris Convention and PCT. So, if today you are filing in India and parallelly you are filed in 5 other foreign countries, then it is your legal duty under Section 8 of the Indian Patents Act to file Form 3 and a statement and undertaking that these are the other countries in which I have applied for the patent for my same or relatively same invention, and I am only the applicant. This declaration and statement you have to furnish to the patent office, and you are supposed to generally update it every 6 months to the patent office that this is the condition of the prosecution proceedings that is going on in USA, in Japan, in Germany in respect of my patent application. Okay, this is a legal mandatory requirement of section complying to Section 8 Form 3. Then we have Form 5, which is declaration as to inventorships, which is a form which shows who are the inventors of the invention that is claimed and who is the applicant. And Form 26, which is generally we usually term it as the power of attorney, which is the legal right given to a patent agent along with other advocates if necessary for filing of the patent before the patent controller and arguing before the patent controller if there is a hearing, and take all the other necessary legal steps and comply with the Patents Act and rules until grant of patent. Along with all these forms, there is something else which is called proof of right, which has to be submitted to the patent office within generally 6 months of filing of the patent application. So what is proof of right? Proof of right can be in 2 ways. I said in Form 1, the university, if it is applying, university of the company, then it becomes the applicant, and the people in the university of the company who did that application, who did that invention, they are the inventors. Okay. So Form 1 has a specific requirement which will tell you who is the applicant, who are the inventors, and that the inventors have given the assignment right to the applicant to file the patent. Assignment right in very, very simple meaning word. Assignment is a legal term. Assignment means you are assigning wholly and totally all the legal rights that is vested in this invention to the university or to the company. This is the meaning of assignment. It is equivalent to sale. Okay, assignment is equivalent to sale. In property also, plain property means when you are buying a house, if there is an assignment deed, it means it is basically equivalent to sale deed legally. So assignment is sale. Okay, and so now the inventors do not have the right anymore as the applicant. So if today there is an infringement of the patent which is held by the university will have to file a infringement suit. The inventors individually cannot file the infringement suit because they are not the owners of the patent. They are the inventors. Okay, but the ownership will lie with the applicant. So proof of right that you have assigned this right to that company you are working for or the university, that needs to be submitted either through Form 1 in original or through an assignment deed on stamp paper. Okay, what is the value of that stamp paper? That needs to depends on state to state under the Indian Stamp Act. Okay, so these are the important things, and this is the last slide. And as I was saying, what is the cost of filing a patent? So last 4th of November 2020, during the Corona period, government reduced the prices of filing, and now the price, okay, for natural person or a startup or small entity, okay, if either of them are filing, then for a patent application having 30 pages of written description and up to 10 claims, then the price is 1,600. Okay, and 1,600 meaning multiple of 1,600 in case of every multiple priority, because I said patent will be given for claims. If you have multiple claims with multiple priority, then your patent application will be 1,600 into number of priorities. So generally people have only one priority and it is 1,600. Okay, and if your number of pages exceeds 30, then per page exceeding 30 is 160 rupees per page, and if your number of claims exceeds 10, then from 11th claim onwards per claim rupees 320 per claim extra. Okay, this is only for natural person or startup or small entity. And if there is a biologist, you can also have sequence listing, nucleotide sequence listing. Okay, then your nucleotide there is 160. The limit is 160, subject to a maximum of 24,000 rupees. Okay, so this is the if you're submitting nucleotide. Otherwise, these are the things. However, if the company is not falling, if the applicant is not falling under natural person or startup or entity, like a big company like Samsung, Microsoft, or a university, or big corporates, then they will be termed others. So if these others entities individually file or they file along with a startup or a natural person or small entity, then the price is not reduced price. It is the price is high. The price is 8,000 rupees per patent application for 30 pages and 10 claims, and per if it is exceeding 30 rupees per page 800 rupees, and if it is exceeding 10 claims per claim 1,600 rupees per claim. And if it coming for nucleotide, it is 800 rupees, maximum 1,20,000. So there is no utility monetary wise in terms of patent filing fee to the government. This is called the official fee which the government is going to take. Okay, this is not the professional fee of any professional person who will help you do the whole thing, drafting and everything. For that, along with this, generally people charge a professional fee. Okay, so this is the e-filing fee to the government of India. This is the money that is going to go into the bank, into the vault of the government. So if there is a university or a company which is working with a startup and they jointly file a patent, both can be the applicant. There is no legal hurdle for the university to be a joint applicant with a startup. But the fees that needs to be paid is not that of a startup. It is that for the others entity. Okay, so I just wanted to have this clarification and a little bit of idea regarding how much is the patent filing fees. And in my previous talk, I said what is generally the timelines of application and what are the kinds of claims, what are the importance, how you should write different parts of your patent application, what is the legal requirement, and so on and so forth. And now I hope if you see a patent application and if you kindly follow what I said, now when you will read a patent application, you will be able to follow and see that whatever I have said, the people who have drafted it have written it exactly on the same lines, and it will be very easy for you to understand what the patent is about and how to write that. Okay? So with that, I will end my talk for the second session. Thank you everyone for this kind patience of attending 2 lectures back to back of mine, and it was wonderful sharing my a little bit of experience that I have. It's a very difficult topic to speak in such a short span, but I tried my level best to give at least an initial introduction, an idea to people who are interested in this field.
Thank you very much, Dr. Indranil Saha. Indeed, we do have some idea. We'll not be completely lost if we reach a position of trying to file an application, and we will know at least the basic do's and don'ts.
Yes.
So that is something which is very, very important. And after that, of course, if we need to get some extra advice, then of course we will always be able to approach you.
Yes.
Right. So thank you very much, sir. We will end the session here. And in these COVID times, you have taken so much of time out, and you have provided us with a lot of knowledge and a lot of information, and with a lot of hope as well. So we can now, instead of feeling bad and feeling down, we can work towards doing something really worthwhile. So many, many, many thanks from Techno India University, from Institutions Innovation Council, And with everybody's permission, can we end here today?
Yes, you stop now.
Hello?
Thank you so much, everyone.
Thank you so much.
Thank you, thank you, thank you. Then
Thank you, everyone.
we will end the meeting here. And tomorrow we meet for another intense session with various experts. So all the best for tomorrow. And thanks again to the expert. And we end here.
Thank you, ma'am. Thank you.
Minutes prior to the session timing, so that we can start the sessions at 5 tomorrow with our speakers. Thank you, everybody. Have a great evening. Bye bye.